Your full name. What up, sir? What up, sir?
ಹೇಳಿ ಸರ್.
ಸರಿ ಸರ್, ಆಡಿಬಲ್ ಇದೆ ಅದಕ್ಕೆ.
ಓಕೆ ಸರ್. ಓಕೆ. ಚೇಂಬರ್ ಬ್ಯಾಂಕ್ ಒಂದು ಅರ್ಜೆಂಟ್ ಸಾಹೇಬ್ರಿಗೆ.
ಕೋರ್ಟ್ ಆಫ್ ಸರ್,
ಹೇಳಿ.
ಇದು 24ನೇ ಕೋರ್ಟ್ ನಿಮ್ ಕೋರ್ಟಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಅಂತ ಬಂದಿದೆ. ಹಲೋ,
ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಸರ್ 24ದು
ಆಗಿದೆ. ತಗೊಂತಾರ ಏನ್ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ತಾರ ಅಂತ
ಸಾಹೇಬರು ಬರ್ಬೇಕು.
ಓಕೆ
ಸಾಹೇಬ್ರೆ ನಮಸ್ಕಾರ, ಚೆನ್ನಾಗಿದ್ದೀರಾ?
ಚೆನ್ನಾಗಿದ್ದೀನಿ ಸರ್, ತಾವು? ನಮಸ್ತೆ.
ಥ್ಯಾಂಕ್ ಯು.
More 052. Another penal hearing 763. Attack. I'm at 2 centimeters.
For 24 matter.
Tomorrow. Yes.
No, that all elections matters tomorrow. Give that memo. That cooperative. Wait, madam. Election matters. Give. Election tomorrow. You give it at 2:30. No, the day after tomorrow. Tomorrow you can get it. Yes. Only elections tomorrow 2:30 will take it. Others tomorrow. Yes. Wait. First we'll take.
Not one matter. MSA 3 times we have moved. It's not listed. The trial court day by day, they are taking up the matter.
MSA,
MSA, remand matter,
Monday, ಅದು ನೋಡಿ ಅದು Monday.
Monday.
Yes. Yes, what is that order you are challenging here? What is the next date? What is the next date there? Yes, yeah. Friday. Yes, Friday. What is that another matter? Tomorrow. Yes.
Your lordship.
What is that matter?
Yes. Yes, sir.
Your both are. You want to refer the matter to Lok Adalat Monday. Lok Adalat ಯಾವತ್ತಿರೋದು 9th ಇರೋದಾ ನಾಳೆ. Yes. Monday.
Election is tomorrow.
Yes, tomorrow elections 2:30. Tomorrow.
The main matter within 6 months from now the I can't wait now is posted for orders of the year, not extension time for soon.
Monday. Tomorrow. Yeah. Tomorrow. Tomorrow. Yes. Yes.
Number
That motor vehicles matter in portal number is
24.
24. We will urgent that next week unless
Problem.
that matter is there is any admission.
ಅಡ್ಮಿಷನ್ ಕಡಿಮೆ ಸ್ವಾಮಿ 2012-13 ಎಲ್ಲ ಇದೆ.
Ade yavdo there is no executions appeals and all. We'll have it this matter on next week. All
Okay.
matters will be urgent next week.
Problem.
Nobody need not wait. Ella official file mad retirement. Yes, all the matter will be urgent next week. Yes.
Number 12 matter list for page wise adjournment, list number 1, page number 1, serial number 1 to 3, page number 2, serial number 4 and 5, page number 3, serial number 6 and 7, page number 4, serial number 8 to 11, page number 5, serial number 12 and 13. Serial number
Serial number 12.
Alienation.
Yes, what you want? Week's time is granted to comply that out subjection.
Page number 6, serial number 14 to 17. Abhi Sadashivappa.
You have informed. Yes, at the request of counsel for the respondent. Read this matter next week.
Page number 7, serial number 18 to 22. Page number 8, serial number.
Yes.
Page number 8, serial number 23 to 29. Page number 9, serial number 30 to 34. Page number 10, serial number 35 to 42. Number 11, serial number 43 to 50.
Malad, serial number 43. I'm for the petitioner. I've received
Yes.
the copy of objections today, Malad. I seek for a week's time for hearing, Malad.
You are,
Sriram Timappa Nayak.
yes, I have for dispensation. Where is that? You are appearing for which respondent?
I'm for the petitioner, Malad. I'm for the petitioner.
You are the
Respondent-
petitioner. Yes,
Yes, Malad.
yes, next week.
A date may
Yes,
be
sir.
given, Malad, for
For
argument.
the request of counsel for the petitioner, read this matter on Wednesday.
Obliged.
Page number 12, serial number 51 to 62. Page number 13, serial number 63. Page number 14, serial number 64. Number 1 for order, serial number 1, Rajesh A. For petitioner, P.M. Jaideva.
Conditional order. Counsel for the respondent number 2 seeks time to comply with the office objection. In the meanwhile, the petitioner furnish the PF issue notice to the furnishing which the petitioner against the respondent. Yes, Mr. Respondent number 1. On Sports 1, represented by managing director. Represented by its managing. ಇಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? No, that you are a plaintiff or a defendant. For the plaintiff. Why they have made it in 2 different names, Mister? That is your plaintiff, your petition. Then what is this, Mister? ಅಷ್ಟು ನಿಮಗೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಗಳಿಗೆ ಪೇಷನ್ಸ್ ಇಲ್ಲ ಅಂತ ಸೇಮ್ ಪಾರ್ಟಿಗೆ ಆಯ್ತ್ರಿ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಅಡ್ರೆಸ್ ಟು ದಟ್ ಪರ್ಸನ್ಸ್ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಸರ್ವ್ಡ್. ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದು ಅವನು ಸತ ಹೋಗ್ಬಿಟ್ಟು ಅವನ ಹೆಸರು ಹಾಕ್ಬಿಡ್ತೀರಾ ಹಂಗಾದ್ರೆ? ಎಸ್, who is appearing for D1 here? R2 ಗೆ R2 R1 is same. Yes, you will take notice. See, Swan Exports India Limited ಗೆ respondent number 2 ಗೆ ನೀವು ಅಪಿಯರ್ ಆಗ್ತಿದ್ದೀರಾ ತಾನೆ? ಫಸ್ಟ್ Swan Exports India Private Limited ಅಲ್ಲ ಚೇಂಜ್ ಆಗಿದೆ, ಈಗ ಒಂದಕ್ಕೆ ಚೇಂಜ್ ಆಗಿರುತ್ತೆ, ನೀವು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ. Then you appear others also, you change it. What is that amendment? Now you take. Yes, now you will take notice. Yes, B and Jaidev is undertake to appear for respondent number 1, of which is directed to show his name. Yes. Now, what is this matter? Yes, Mr. What is it? Yes. ಏನಾಗಿದೆ ಇದು? ಅಡ್ಮಿಷನ್ ಆಗಿದೆಯಾ? ವಾಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್? No, now you want to withdraw this. If you proceed there, if this is allowed, then further suits can be proceed. There is no problem. Yes, post this matter for admission.
Number 2.
Next week, yes.
Number 2, Nabil Ahmad.
Non-compliance. Yes. Yes, 2 days time is granted to comply that of subjection. Is this matter on Tuesday?
Number 3, Rudrappa P.
Week's time is granted to comply that of subjection.
Happy for serial number 4 minute.
Yes.
Serial number 4, happy for appellant.
Yes.
That in this case, minute, the brothers respondent 2 to 4 minute, they filed a P&SC case without
Yes.
making the appellant and her mother respondent number 1 as party to the proceedings. And minute, by filing leave application, minute, we have filed this appeal. That office has raised objection that necessary application is not filed. That
Yes.
application is filed, minute, seeking leave. That's the only minute legal complaints minute the petitioner could do.
Have you filed an application for permission?
Yes, minute, seeking permission, I filed minute. Last
So the applications not filed antide?
file ಮಾಡಿದ್ದೀವಿ sir.
File ಮಾಡಿದ್ದಾರೆ.
With the second application,
Learned counsel for the appellant has submitted that the appellant has filed an application for leave of this court to prosecute this appeal. It's seek for overruling that office objection. Submission of learned counsel for the appellant is accepted. Office objection is overruled. Post this matter for admission.
only minute, small, minute, the grounds on which minute the appeal has been filed. Is
Yes.
minute, when the, during pendency of minute partition suit, minute, the
Yes.
brothers minute after
No,
filing
but
partition suit.
Srikant
and-
Gowda, no, other side is not there.
Because it's for posted for admission.
Yes, we are directed to post this matter for admission. Yes.
Serial number 5, Ajay Jain.
And last me kindly minute, Monday minute,
Yes, yes.
Monday minute.
Yes, next week it will come. Yes.
Serial number 5, Ajay Jain for appellant,
sir.
Prakash P. Abbar.
Urgency because of their apartment, they're stuck, they're not ready to wait for 1 week.
No, 1 week, nothing will happen, Mr. 1 week will fix the date next Friday, next Thursday.
Not actually matters, has to be listed because paper publication. What the other unserved respondents?
Yes,
Are they equal? Are a paper publication after served? and-
yes, tomorrow, yes,
ಆಮೇಲೆ
yes,
Again, I have some progress.
yes, please this matter tomorrow.
6, Srinivasa Babu for appellant.
Yes, weeks at the request of counsel for the appellant, release this matter next week.
Number 7, Bharat K for appellant, Rishi Sanjay. Connected matter.
Yes, at the request of counsel for appellant, release this matter next week. Next week, yes, next week or today, yes.
Serial number 8, Mohan Chandra P for appellant.
Yeah, conversion of CRP. Why? What is that order you are challenging? Order passed by? Hmm. Office has raised an objection. Yes, learned counsel for appellant has filed a memo seeking direction to convert this appeal into the CRP. Memo dated 5/9/2023 is taken on record as requested by appellant. Office is directed to convert this appeal into civil revision petition. Yes. For a statistics purpose, appeal is disposed of.
Serial number 9, R Kumar for appellant, government advocate.
Yes, Mr. Yes. Yeah, no, observation in-
Yes. Shall I allow a copy to be filed to verify date of 4/1 notification and award?
Yes, copy, you furnish the copy. Office, you give it in that office. Yes, that is the objection. Yes. But it is served to all. Yes, you file it in that office. Office is directed to secure that original records. Original record bandidya. Yes, will secure that records, government? Yes. Then only announcement. Which is that place? Covered by decision. Is it, madam? Yes, is it a similar notification announcement has been made? Yes, you have to verify, Mr. It is covered or not? When do you want? Copy code. He is the beneficiary. He has to say. Yes. Not going to then if it is correct, then the records are not necessary. We'll have it next Friday. Yes. In the meantime, we file this matter on Friday.
Serial number 10. Rangareddy Shankar.
I have filed a memo for retirement in this matter for petitioner on 21/8/23 for retirement.
Memo dated 21 to retirement filed by the advocate for Sri Basuraj Banur. Yes. Learned Counsel Sri Basuraj R. Banur has filed a memo for retirement. Memo is accepted. Is permitted to retire from the case.
Acha, please.
You also filed an NOC. You are appearing now that Kumari M is retired from. Yes. Kumari M is our memo hakidara has filed a memo seeking retirement from the case as a respondent, counsel for the respondent. Memo is taken on record. Kumari M is permitted to retire from the case. Yes. Is it admitted? The emergent notice to the respondent. Amount order to be paid by the petitioner hearings as per the Timpun order subject to result of the petition. To be paid by the. Yes, there is. No, there is an order. Interim order has been granted. No, that court said it is subject to result. If you succeed, then we'll direct him to repay that amount. No, that. No, unless that order is modified, I can't do anything. Can I pass a contrary order which is already passed by this court? Or you have to file an application for recalling that order. There cannot be a inconsistency with that order passed by this court. I will dismiss that application in view of that order. Mister, you have to file an application for recalling that order. Then you seek for a modification. Yes. Permitted to retire. Furnishing PF not in the correct address issue notice to the. Respondent. Who? What is that respondent name? Aisha Siddiqui. Respondent number? Before the family court, Petitioner. Aisha Siddiqui. Shimoga. Then you have to furnish correct address. I three our change agitra. Then take hand summons. Hand summons. Yes. Yes.
CW1 is present, she is the mother in law of A1. She has submitted that petition number 1, that is the petition hearing. CW, that is the respondent number 1. Three together number. After the final order passed by. Three together, they are actually in 10.
Oh,
Looking at the petitioner and the respondent. After the passing of the maintenance order to the higher court, they are claiming the maintenance.
who is residing together?
Husband and wife.
But who is now claiming that company?
After the passing the order, they now started claiming the maintenance. Together, filing the final order to take together. Actually, short time membership in CC number 909. 498 filed by the mother-in-law.
No, that order for which is challenged, the address is given different. Your address is different and her address is different. There you have not disputed that. Have you filed an objection there that we are living together? ಆಯ್ತ್ರಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನೋ ತಪ್ಪಾಗಿದೆ. ಹ್ಯಾವ್ ಯು ಟೇಕನ್? ಆಯ್ತು, ನೀವು ಅಲ್ಲಿ ಮೇಂಟೆನೆನ್ಸ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕಾದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರಾ? ನಾವಿಬ್ರು ಜೊತೆಲಿ ಇದೀವಿ ಅಂತ ಹೇಳಿದೀರಾ? ನೀವು ಜೊತೆಲಿ ಇದ್ರೆ ಆಯ್ತ್ರಿ. If you are living together, is it not your contention before that court that we are living together? There is no question of maintenance. Now you are changing that your version. No, you forget about that. Have you taken this contention at the first instance? ಅಲ್ರಿ, ಅವ್ರು ಹೇಳದ್ ಬಿಡ್ರಿ. ನೀವೇ ಹಸ್ಬೆಂಡ್ ತಾನೆ, ನಿಮ್ ಜೊತೆನೆ ಇದ್ರು ತಾನೆ, ನಿಮ್ ಜೊತೆನೆ ಇದ್ದು ಮೇಂಟೆನೆನ್ಸ್ ಹಾಕಿದಾರೆ ತಾನೆ. When you appear, first your objection is that yes, you take steps, Mr. Yes. What is the stay? Why that stay is not granted in earlier occasion by this court? Proxy counsel for the petitioner seeks time. Issue notice to the respondent. Interim order is not granted by this court. Again, Dubai and what is this? There you are residing, Mister. You are in the Dubai. What is the order passed by the family court? 20,000. ಎಷ್ಟು ಕಟ್ಟಿದ್ದೀರಾ ಈಗ? ಎಷ್ಟು ಕಟ್ಟಿದ್ದೀರಾ? ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ದೀರಿ? ಪೂರ್ತಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅರಿಯರ್ಸ್? ದುಬೈಲಿ ಬಿಟ್ರೆ ರೀ, ಮೇಂಟೆನೆನ್ಸ್ ಹಾಕಿದ್ಮೇಲೆ ಎಷ್ಟು? ಪಿಟಿಷನರ್ is hereby directed to pay monthly respectively from the date of petition. ನಾವು ಏನು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದಾರಾ? ಎಲ್ಲಿದೆ? Where is that execution petition? ಏನಾಗಿದೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್? Yes. They have further proceedings in series 41 of 2023 pending in the file of family court at Shimoga, subject to condition. The petitioner has to deposit 50% of that arrear amount within 2 weeks from today, 4 weeks from today, and he is directed to continue to pay further maintenance of rupees 10,000 per month to the respondents. Yes, monthly. ಮಾಡ್ಬಿಟ್ಟು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆಗ್ತದೆ. Yes. Subject to condition, 50% of the arrears amount within 4 weeks and directed to pay continuous monthly maintenance 10,000 per month.
Number 12
And furnish the correct address, Mr. Weeks time to furnish correct address to issue notice to respondent.
Serial number 12 at 12, serial number 13, Chandrakant Arpode for petitioner.
My lord, I appear for the petition in the first rate petition, my lord. My only prayer is to hold direct respondents to hold elections, my lord, for respondent number 5 society. No elections are being held since 2016 onwards, my lord, till date.
Yes. Who is appearing for other side? Yes, this matter on Wednesday. No, anyhow, that only one day I have this roster. Why all this? I will have it on Wednesday. Wednesday.
My
Anyhow,
lord, they
date
are
is,
unnecessarily taking time, my lord. I am really not concerned with connected cases.
yes, lease this matter on Wednesday. Yes.
Much obliged.
Serial number 14, Manoj.
Interim order granted earlier, if any, is extended till next date of hearing.
Serial number 14.
No, Wednesday, you asked before the same court. Yes. Tuesday.
My lord, this is advocate.
No, they are saying that last so many years, election has not been held, Mr. Huh?
From 2016 onwards, my lord, elections are not held.
One ನಿಮಿಷ ನಿಮ್ದಲ್ಲ ಒಂದ್ ನಿಮಿಷ.
I do Tuesday. Thursday, yes. Next Thursday.
Serial number 14.
Interim order granted earlier,
Amen.
if any, is extended till next date of hearing.
My lord, may I please your lordship,
Muhammad Tahir.
serial number 14. This is
Yes.
advocate Nidambara, my lord, from Bombay. My lord, there is an interim order which was in operation, which came to be, vacated because of non-appearance.
What is this, Mr.?
And now my lord,
Yes.
my lord,
Who is appearing
after
for
the-
instructing counsel? You are there. Is there any interim order?
There's an interim
Is
order
vacated.
which was
From Delhi,
vacated
it's
for.
saying it is there.
No, my lord, the all issue is an interim order which was in operation came to be my lord, vacated because of non-appearance. I couldn't come, I
Yes.
was not, I couldn't come. And therefore, my lord, now I filed an application for
Yes.
recall of the order and restoration of
Then
the.
we will have it
interim order.
next Wednesday. Yes,
No, my
before
lord,
the regular bench.
No, my lord, till that, my lord, no. further
Interim order is
proceedings.
already vacated. What I can grant,
No, my
Mr.
lord, my lord, the all issue is, my lord, your lordship have
Huh?
all the powers, my lord, and the.
You have filed an writ appeal.
My lord, I
Then
filed
how
a-
can I extend that interim order?
No, my lord,
If there is an,
until the appellate court takes a decision, there is no kind of.
how can Mr. When the matter is seized by that appellate court, I can grant
No,
interim
my lord,
order.
it is not seized by the appellate court, but it has only,
Then-
it has not been, it has only been missed on that, it has not been heard.
That itself,
Once
it
it's
is
up-
not seizing by the as police IPC.
No, my lord.
When the matter is
document- my
before
lord-
that division
my
bench,
lord-
how can I grant interim order?
No, my lord, there's a concept in presentia majoris, societ potentia minoris. In the presence of a superior forum, the inferior forum has losses power jurisdiction. That's a concept. That's a concept belonging to the
No,
doctrine of estoppel.
We will
That-
have it
that
on
applies-
Tuesday. Mr. Counsel, it will have it on Tuesday before the regular court.
My lord, my only problem is they are, my lord, when
Yes,
they
Tuesday,
take
madam.
advantage, to take advantage of the vacation of the interim order, they are creating third party rights, going with the construction. So many things are being done. And the entire proceedings are without jurisdiction. Original order was to restore
No,
possession.
madam,
To show cause
you
as to
just
why-
see, when an order has been passed by this court, has been challenged before the division bench. Can I pass this order by this single judge?
Yes, my lord. Yes, my lord. No, my lord, if the.
You
my
won't
lord,
convince the division bench. Yes,
No, my lord, supposing that
Yes.
your lordship is.
Yes, Tuesday. Yes,
My lord,
this matter on
my only-
Tuesday.
My only anxiety is, my lord, supposing that if the division bench hears and either rejects
No,
or
this-
lost my
no,
petition, your
See,
lordship
regular
jurisdiction is
court
lost.
is not sitting only
Yes.
for that ADAC arrangement, this is there. I can't start
I know,
any
my
hearing
lord.
because
No,
only
my lord, I'm-
tomorrow this roster is with me. Therefore, we will have it
Yeah,
on Tuesday.
yeah, I'm completely, my lord, in agreement with your lordship. My only anxiety is that, my lord, they create third party rights and they are taking advantage of the fact that interim order got vacated because of
Yes, till
non-appearance
Tuesday,
of my
nothing will
part.
happen. You move before the division bench, 2:30 or tomorrow. Yes, if division bench grant an order, even we can't proceed.
No, no, I
Yes.
only ask for one accommodation. Let the other side, no, should not
Tuesday,
proceed to do
Tuesday, yes.
anything. No, no
Yes.
precipitated steps should be taken on all understanding till Tuesday, my lord. That is all.
Yes,
I
Tuesday. Yes, yes.
Bharat Kumar, we for petition.
But petition in this case only. We have completed the order dated 14/8/23, my lord. We have deposited 11,50,000, my lord.
Yes, what is this, Mr.? Petitioner shall deposit the said amount within that so and so bank within, yes, they have deposited. Yes. No, that amount has to be deposited in that court or that in the bank. Second respondent bank, yes. No, you have issued DD in your favor. You have to be deposited in the bank. What is the petitioner shall deposit said amount with the respondent number 2 bank within 3 days. It is also not clear whether it's in your name or in his. It has to be 11,50,000 has to be kept in his account. That is the meaning of that order. No, it is not for the clearance. I think it's for an assurance. That's the order is not that. Yes, please. Yes, either you want to seek for a clarification of that order. Petitioner shall deposit that said amount of rupees 11,50,000 with the respondent number 2 bank. Nim bank ali our account ali itar ಅವರು. Whether yes, now that only that petition has been entertained, that you are ready to pay that amount. By reading entire order, that intention is to deposit it to that bank. This thing, Mr. Yes, Mr. Counsel.
My lord, if we give
You want no, you want to clear that loan or you want to keep that money with you? Then it should be in their account, is it not?
yes, we'll deposit, my lord. We'll deposit.
Otherwise, it will carry interest.
Okay. Yes.
You deposit in their name.
Yes, my lord. As per order, we'll clear another 11.5 lakhs also.
Yes, both that you have to be deposited in that yes, loan account.
Okay.
Yes, we'll have it on Wednesday. By that time, you rectify that.
Interim order may be extended.
Yes, reach this matter Wednesday. Interim order granted earlier is extended till next date of hearing.
Okay.
Number 16, Ravindra Prasad, we for petitioner.
You have paid that entire court fee, 17,800. When is that election? Tomorrow. The same similar matter, Mr. Government Educator. Ask their what other that non-inclusion of their name in that voter list. Yes.
Not, may I request one.
But interim order, there is no such this thing is there earlier repetition. Yes, we'll clarify.
They cannot be allowed voting.
I thoroughly heard. To notice. You are taking notice to whom, Mr. Government 1 to 5. Our milk iವರು ಕಿರಣ್ ಕುಮಾರ್ ಇದಾರಾ? ಎಲೆಕ್ಷನ್ ಅಥಾರಿಟಿ ಇಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್. Hmm. Yes. Correctly. 1, 3, 4, 5. Government advocate is directed to take notice. Learned counsel for the petitioner is directed to serve 2 sets of copies. TL Kiran Kumar, Allah?
House.
Yes. TL Kiran Kumar is directed to take notice for respondent number 2. Learned counsel for the petitioner is directed to serve 1 set of copies. Issue emergent notice to respondent number 6. The returning officer, respondent number 5, is directed to permit the petitioner to participate in that election to be held. Permitted to cast their vote in the election to the 6th respondent society should be held on 8/9/2023. If the petitioner is member of that society and if they are not defaulter. If they are not, no, any dues. Either if they are members of that society. The interim order is subject to result of this petition. Yes. Who is there and serial number 6061? Council. Cannot there, yes. 6061, I think today is the election. Serial number 60. They are not the member. Yes, mister, you are not member. If they are member, you permit it. Then anyhow, today is the election. We can't do it. Serial number 60 la. Rahul is ready. Then they are not the member. No. 62 will come. Only 60 and 61 today is the election. Then we are not entitled. Even no, that 60-61, then it will become infructuous because today is the election. Yes, the election shuruvagide bidi. Nanu yenadre if they are eligible, I could have permitted. But yes, then we will continue the list. Yes. Yes, 62 will come. Day after tomorrow elections. Yes. We'll see that regularly. Yes.
Here interrogatory application matter, serial number 17 urgent, serial number 18, Shivanna for petitioner, Madhvacharya M.
One time. Yes.
Section 43, they have to produce it. They have not produced the element of implicit.
Oh, you have disputed that.
My mother-in-law was the agreement to say. They purchased from the earlier landowner. The tenancy is not, there is no tenancy at all. I purchased that property under an agreement of sale. The original owner, who they have not registered savings certificate.
Now that why that delay in filing in a
Because some of the petitioner died because of the market.
Yes, Mr. You file in a better affidavit to explain the delay first. Yes, next week. Oh, first I have to condone the delay. Where is that? No, but I have to condone the delay. You have not explained the delay. We'll see that. Where is that application? No, when that order has been passed, Mr. 17 August 2022. Yes, when that your son died, Mr. ಅಲ್ರಿ ಮಗ ಸತ್ತೋಗಿರೋ ಡೇಟ್ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ when he has died. Also, you get the date from your party. Also.
Number 19, Dhananjay SCP for petitioner.
Yes, notice. There is a delay. How can grant interim? Delay 1 day or 4 days is the same. No, without giving in a notice, how can condone, Mr. Yes, that is a ground for condonation. But it cannot be condoned without giving a notice to other side. You take hand summons. Yes, issue notice. In addition, petitioner is permitted to take out hand summons to respondent. Yes. You serve a hand summons and move the matter. Yes.
The matter serial number 20, Manju Prabhakar for petitioner, HB Rudresh.
Yes. No, you give that brief fact. What is the suit for? Why execution petition? Yes. Arbitration. Yes. Yes. You are also party in that arbitration. See, arbitration cases between that claimants and two respondents. You are that respondent or a claimant? Respondent number 2. Kailasam. Yes. Then what is that settlement? Which respondent?
It was respondents 1 day together.
Yes, agreed to pay to that claimant. Yes. 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 Yes.
While execution, they are not taking steps against the company or property. There, we can make an application to arrest me.
Now, what is that company default that director has to be arrested, or how can that arrest the company? What is the law on that point? Is it director is responsible or the name of the company? No, any act of that company is by that director.
By the director. First, they must.
No, I'm asking that what is the law on that point? If there is any execution is filed against the company, whether director can be arrested? Show me that law on that point. That is the. Yeah, that is the question now. If you say that there is no such, then the entire order has to go. Yes. Who that degree order? Yes. Hmm.
If I did beyond a period of 30 days, then I guess says the restoration application can be by within 30 days. It cannot be by. There is no scope for cancellation delay. Submission.
Yes. 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 When it is dismissed for default. Hmm. 2021. Yes. Then the application is filed.
Application is filed on 13/1. After a period of 1 month.
Yes. Yes, which is the judgment? Yes.
The starting page was page 115.
Yes. Yes.
Please see page 170, first paragraph itself. Question which may for consideration.
Pardon?
Interpretation.
Which underdone? 17.
17.
Yes.
Interpretation of sub 106 of 121 of CPC. Also consideration of this appeal, which arises from the judgment order against after the hereby number was dismissed. Similar. In fact, para 3 was changing.
Yes.
Similar facts also there. The respondent hearing is gathered for some of the case and so number was so and so. Secondly, the said was marked as the first. The said execution hearing. It was dismissed for inward on 1/11/1990. It was also not in dismissed that an application for restoration of the said execution was filed by the respondent hearing on 4/4/1998. Interim of the revised that it gave to learn about the dismissal of 25/3/1998.
Yes.
And then onwards, where there is a discussion.
Yes.
The
Yes.
learned judge, however, while arriving at the said finding, they had not neglected to consider the effect of supplemental 106. Now, their producer of the government should clearly go before that. When an application is important, support 205, the starting point of limitation application to be the date of the order and not the knowledge thereof. As the applicant is represented in the proceeding to his advocate, his knowledge of the order is presumed. The starting point of limitation being knowledge about the disposal of the execution bench. And only in a case that is far and thus, if an order has been passed dismissing an application for default up to 205, the application for restoration thereof must be filed only within a period of 30 days from the date of the said orders and not thereafter. In that view of the matter, the date should decree holder acquire the knowledge of the order of dismissal of the execution petition. But there are only irrelevant. Fixed by the provisions of the code
Providing section 5 of the Alienation Act, they file. We get inapplicable according to the Alienation Act 1960. Also, right that the civil court in the absence of any express power cannot do the delay. For the purpose of continuation of delay, in the absence of applicability of provision of the Alienation Act, court cannot be moved in the that when a power is to be exercised by civil court under an express provision, inherent power by the Alienation Act is not maintainable in a proceeding arising under application of the said provision has thus expressly been excluded in a proceeding that was the matter. Even an application of the section by the Alienation Act, if what your name from purpose cannot be on this it is allowed in that, right?
Now here application is filed.
Application is filed. The application of what is filed at page 92. File on 13/1/2022.
Yes, mister. There is no provision for condonation of delay.
Hereafter, we have filed and civil court issued the summons where they appeared. Thereafter, warrant was issued. After warrant was issued, they were appointed the court payment to that application. Hereafter, they have changed their mind. We are not liable to pay the court amount because I am not the director. I have been retired today. So much company. Then we not say that the SOP is extended till.
No, that is not the issue. We are asking.
After issuance of first warrant as against the area, they have 5 days increase in people's number code. They have suppressing period of past people's number code. They have produced all the documents except the requisition. Through the pendency of the requisition, the requisition stay has been granted by this number code. Therefore, I could not take the stuff from the fire code. That is that they have taken the advantage. They have cited this report till 5:30. They have dismissed it. They have made this execution. You are produced the requisition order, stay on the copy.
No, that is not the issue. It is dismissed for default.
This is why the very court wrongly dismissed the execution.
No, the reason is.
The reason is not. I have not taken the steps. DHL have not taken the steps. Therefore, the execution is dismissed. But if the requisition, there was a stay order. I cannot take the disposal of the requisition. I cannot take the steps. So therefore, I cannot take
No,
the steps.
see, whatever the reason, if it is dismissed by that court, it is in a dismissal. That court has a power to seize, unless if you recall within 30 days. If you have not filed an application for 30 days, the remedy is for you to either you have to challenge before this court for dismissal. No, no, that is no. I am not on that reason. I am on that law. After 30 days, the court has seized their power to recall. Either you have to challenge that order before this court and get it set aside. There is no power for recall. That's what the Supreme Court said. After 30 days, there is no section 5 limitation application is applicable. No, no, you just answer this question of law. We are deciding on that. We are not. So on that facts, you are right. But law, this is the law which says that by Supreme Court judgment. Is there any judgment which overruling that are distinguished by the Supreme Court? Yes, we'll grant it. Today it is for what? Yes. ಆಯ್ತ್ರಿ ರಾಂಗ್ಲಿ ರೈಟ್ಲಿ ಡಿಸ್ಮಿಸ್ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸಲ್. ರಾಂಗ್ ಆಗಿ ಆರ್ಡರ್ ಮಾಡ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ ನೀವು? ಇಲ್ಲಿಗ ರಿಟ್ ಆಗ್ತೀರಾ? Yes. No, ಅಲ್ಲಿ court mistake irbodu. Dismissal is dismissal. If any mistake by the court also, you have to challenge before this court, or you have to recall within 30 days. ಆಯ್ತ್ರಿ ಅವ್ರು ತಪ್ಪು ಇರ್ಬೋದು ಅದಕ್ಕೆ. Yes. That is the ground for you while challenging that order of dismissal before this court, and you can say that they have misled the court and get it dismissed. Then we can recall it, or we can set aside that. But that as per the judgment, after 30 days, application is not maintainable. Yes. Yes. Or who is there? Respondents? Any other respondent has to serve? You are appearing for which respondent, Mr. Serial number is to? Yes. You are taking notice to R1. Yes. Caveat HP Rudresh is notice to R2 dispense. Yes. Yes, what you say about the judgment? No, whether I have to follow the Supreme Court judgment or not. See, you are in a council, you have to see that whether you want to distinguish judgment, or that the judgment is not applicable to this, or there is any other judgment. You can't say that Nimige Bitidi Swami and Tandre, then I will admit it and stay. I have seen that for the interest of the parties. ಏನಾಗುತ್ತೆ ಅವಾಗ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ಕಾಗಲ್ಲ, you have to file in a fresh this thing, you have to think it up. Yes, is that judgment is final, or is there any other judgments too? Because this is 2005. Verify, mister. Is it that law as on today? Yes. Judgment ಕೊಟ್ಟ ತಕ್ಷಣ ನೀವು ನೋಡ್ಬೇಕು ಅದ್ರದ್ದು ಏನಾರ ಓವರ್ ಆಗಿದೆಯಾ, ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಾ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ಯು ಜಸ್ಟ್ ಸೇಯಿಂಗ್ ದಟ್ ಎಸ್ ವಿ ಡೂ ಇಟ್ ಅಂತ. ಎಸ್ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ 15. ಎಸ್ ಸ್ಟೇ ಇದೆಯಾ? ಎಸ್. Further proceedings in execution number 4169 of 2018 is stayed till next date of hearing. Post this matter on 15th. You verify that any judgment. 2005-7 SCC 300. 2005-7 SCC 300. Yes. Yes. Password, Mr. Password, he wants password. Yes. At the request of the parties, leave this matter next Thursday. Yes.
22 PM Vishwanatha for Petitioner, we are waiting for the day.
Yes. Yes. Petitioner has filed a memo seeking dispensation, notice, service of notice. What is this matter? Yes. Yes.
One of the parties
Yes.
and not been disclosed in fact.
Yes. Yes, yes, Mr.
Let there be a limited period.
Let us see what is submission. Yes. One time. Yes. Yes. Learned counsel for the respondent press 1 to 6 press 2 weeks time to press 2 weeks times. Then further proceedings in OS number 6002 of 2014 is stayed till next date of it. Yes. Password. Yes.
Number 24, Prasanna Kumar CS for petitioner.
Yes. 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 It was a partition. Yes. Yes.
And let Shrimati Geeta to enter into a partition with on 1/12/2009. The partition, the admit partition, but we do the ask for cancellation.
The promise of allotment large shares to the plaintiff in all other joint.
That's the start. 19 years.
Oh, is there any limitation?
What the Seneca said the partition for revoke the partition. They seek for a declaration that they seek for a reopening of the entire partition.
Yes.
That's not permissible.
Which is that article which is bar for filing in a suit after limitation.
58.
What is-
58, looking for a declaration is 3 years to pay the first cause of action.
Yes.
To obtain any other degree of declaration.
To obtain any other 3 years when the right to sue first.
First the proof.
Hmm.
According to them, in 2009 itself, they were clear aware that they were having given a session. They were trained as it is.
That is in the plaint, they have taken that contention that they are aware that earlier partition.
They are the parties in the partition.
They are the parties. Yes.
Further, it is the defendant is honestly number 1 to 5 and they should be enter into partition case.
Issue notice. They have further proceedings in OS number 488 of 2022 till next date of hearing. In addition, the petitioner is permitted to serve a copy on the counsel appearing for the respondent before the trial court. Yes.
Number 25, Lady Sitaramaya for petitioner.
Yes, Sidramaya. Paso.
Number 26, Gowda R. Patil for petitioner. Harisha yes.
Yes. No, you are a landlord or a land. Your petition is dismissed. No, on what ground? On what ground you have filed? Yes. Or admit it. Yes. Records ಬರ್ಬೇಕಲ್ಲ ಫೈನಲಿ ಹಿಯರಿಂಗ್ ಆಗ್ಬೇಕು. ಇದ್ರಲ್ಲಿ ಏನು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಏನಿಲ್ಲಲ್ಲ. ಇವರ್ ಏನ್ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಯುವರ್ ಪಿಟಿಷನ್ ಇಸ್ ಡಿಸ್ಮಿಸ್. Yes. Office is directed to. Yes. Office is directed to secure original records from the trial court post immediately after receipt of the records. Yes.
Number 27, Nagaraja Rao case for appellant Indushekar PT.
Yes. 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 Is it Municipal Corporation Act or Municipal? Huh? It's Ramnagara. Yes. Yes. Hmm. There's some subsection. Hmm. Subsection B na 3. Yes. Yes.
From the day on which we got. Yeah, I constructed. I was granted in 2018. So here 2 years. I understood started construction. Those are already marketed. First, I have come up. It has been commenced. Once the building has been commenced, I need not obtain a fresh license. Our only obligation is have to give completion to the location.
No, that's now that you are saying that you are under construction. That is also that construction, is it not? Completion of the construction means everything is completed. Of order code of service. Rules. Yes. Yes. Validity period of sanction after the commencement of work at the site and validity period of commencement of the work 2 years from the date of sanction. Actual validity period is completion of work. No, the 2 years we have to complete, but that permission has to be renewed. Otherwise, see, 2 years is that ultimate limitation. They have given us 6 months. If you have not completed again, you have to get it for extension. No. See, 4 years they can extend it. Once license has been issued, otherwise, why they have fixed that time limit, Mr. Building license. ಪರವಾನಿಗೆ ಅವಧಿ ದಿನಾಂಕ 30ರಿಂದ ವರೆಗೆ ಮಾತ್ರ ಅಂದ್ರೆ 1 ವರ್ಷ. This is issued under which provision, Mr.? ಆದೇಶ ಉಲ್ಲೇಖ ಕಟ್ಟಡ ಕಾಮಗಾರಿ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ನಿಲ್ಲಿಸಲಾಗುವುದು. ಪರವಾನಗಿ ಅವಧಿ 80ರಿಂದ 80ಕ್ಕೆ ಮಾತ್ರ. Where you are reading? Yes. No. ಕಟ್ಟಡ ಕಾಮಗಾರಿ ಮಾಡತಕ್ಕದ್ದು. ಪರವಾನಗಿ ಪಡೆದ ಅವಧಿ ಒಳಗೆ ಕಟ್ಟಡದ ಕಾಮಗಾರಿ ಮಾಡತಕ್ಕದ್ದು ಇದರಲ್ಲಿ ಹೊಸ ಪರವಾನಗಿಯನ್ನು ಪಡೆದಕ್ಕಂತಕ್ಕದ್ದು. A person should become entitled to subsection not to work of this notice required by the person shall commence such work after the expiry of the period of 1 year. No, you see that 187.6. See, Karnataka Purasabhe Adi Niyama 187.6 ರಂತೆ ಪರವಾನಗಿ ಪಡೆದ ಅವಧಿಯಲ್ಲಿ ಕಟ್ಟಡ ಕಾಮಗಾರಿ ಮಾಡತಕ್ಕದ್ದು ತಪ್ಪಿದಲ್ಲಿ ಹೊಸ ಪರವಾನಗಿ ಪಡೆದಕ್ಕದ್ದು. That is what that 187.6 says. From the date on which we first become entitled with unless the fresh application. Yes. 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 Now you come to that facts of the case. Just to what is this matter?
Item number 30. For which he has not even applied for the license. He was presently there and I could not. But after that, he was for which.
No, is that license, that property's name has been mentioned in the license. License ಅಲ್ಲಿ ಯಾವ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳಿದಾರ? ಅರ್ಜಿ ಸಂಖ್ಯೆ ಸೋ ದಿನಾಂಕ ಅರ್ಜಿದ ಇದಕ್ಕೆ ನಕ್ಷೆ ಅನುಸರಿಸಿ ವಾರ್ಡ್ ನಂಬರ್ ಸಂಖ್ಯೆ 27ರಲ್ಲಿ ಮಾಲೀಕತ್ವ ಸ್ವತ್ತಿನ that this is that they have mentioned that ಖಾತೆ ಸಂಖ್ಯೆ 2031A.
It is item number 30.
No, that permission will be on only 2031A.
31 is item number 30. But the construction is at item number 2031B.
Wait. No, I will permit only in respect of that 2031A. This is item number. No, that is item number 13. Oh, that is only permitted. Where they are constructing? See, we will be permitted only in that where he has taken a license. If you are constructing somewhere else, they can. Now we will come to that fact. We will see. Wait, we'll answer. Yes. Yes, Mr. What is this case? Yes. For that partition suit. No, in the partition suit, yes, the plaintiff has filed for FDP. You are that one of the co-partner. Yes. Yes. No, that you have filed an application.
They were in these proceedings.
No,
Whether the payment of application for the injunction.
yes,
Court and status for.
injunction restraining that. Where is that application? Page 85. No, scheduled is mentioned. 12ನೇ ಪುಟ ಸ್ವತ್ತು ರಾಮನಗರ ಜಿಲ್ಲೆ BM ರಸ್ತೆಯಲ್ಲಿರುವ ಖಾತೆ ನಂಬರ್ 12972031B. Is there any license for this property? This is the property where injunction has been granted. Huh? Is there any license for construction of this property? No, that injunction is only for this. If there is any other property, there is no injunction, you go ahead. Their injunction is. Yes. That license is for which? Two 2031A, there is a license. 2031. No, he will be permitted to continue only in that item number 13. 13 other. Item number 13. No, 13, if he has taken a license, subject to result, let him continue. Where is it? Yes. No, he may ask 12. Wait, mister, when he is submitting, see, now he is constructing that illegally in 12. Why you have asked 13 also? No, you have asked for 12 and 13. According to you, he is constructing in 13, 12. Why you have asked for 13? Adike.
Therefore, these are. That is how the injunction is called.
No, all that will be decided in the FDP. For 13 is concerned. Yes. No, I am not giving, Mr. Council, we are not giving a share to him till this. Yes. Yes. Yes.
It is pending. Therefore, he is purchasing the entire decree. The decree is all the government. We have not restrained the.
Yes, yes. There are 13. Yes. No, you reading para 13. Hmm. 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 Hmm.
We have also not denied. It's not that we are undertaken the construction in the partition sector. I don't know about that one, but
Wait, Mr.
One way in the representative to item number 12 property and not the representative to item of property in other items also. After this point,
No, that we will appoint that court commissioner. We identify. Wait, Mr. If you are taking in a permission to that item number 13, if you are constructing in 12, we'll direct the authorities to demolish that because you are violating that condition. We'll appoint that court commissioner. Yes. We'll verify that whether it is construction in that suit scheduled item number B or 13 or 12. Yes. Who will be that appointed? Yes. Let us see. That is the only dispute. Even 13, if it is find that 13, subject to that without claiming any equity will permit. But taking 13, you should not construct in 12. Yes, that's why that observation of that. Will who is that court commissioner we can appoint? Anybody? Who is which is that place? Ramnagara, any advocates from that place? They can take their 1 day holiday to their native place also. Yes. Anybody is there from Ramnagara? You suggest any one advocate, Mr. Both of them. Both of them. Gangadhara, you can do that, or you are a busy man. You are yes. Any other young advocates? But I don't know that who is that advocate. Yes. Huh? Yes, Mr. Who is that? Yes, Mr. You can. Alright, I am not. I understood, Mr. I am. That, Mr. That has to be decided. Yes. No, if he is. Yes, Mr. You can do that the commissioner work in that, which is that place, Ramnagar. Yes, we have any Saturday or Saturday you can do it. Yes. It is appeal. The appeal is arising out of order passed on A. 1 filed under order 39 rule 1 and 2 by the degree holder by the plaintiff in FDP 15 of 2020-21, seeking restraining that appellant herein from putting up further construction in suit item number 12 and 13. Learned counsel for the appellant has submitted that They have taken all necessary permission and plan and license from the competent authority to put up a construction in item number 13 of the food scheduled property. And they have also started a construction. If they unsuccessful in the case, they will not claim any equity. They may be permitted to put up a further construction in item number 13. Learned counsel for the respondent has disputed that taking a permission to put up a construction in item number 13, and he is putting a construction in item number 12. And they also contended that they have a share in that both the properties. Therefore, he cannot be permitted to put up a construction. Since there is a dispute that the appellant has taken a permission from the competent authority to put up a construction in item number 13, and he is putting up a construction in suit item number 12. Under these circumstances, for the assistance of this court has of the opinion that advocate commissioner has to be appointed to get a report to dispose of this appeal. So and so, learned counsel has been appointed as a court commissioner to inspect that spot and verify whether appellant is putting up a construction as per that license obtained from the competent authority in the suit item number 13 or suit item number 12. That is the only you have to identify which suit item. Both the parties are directed to assist the court commissioner to examine and submit a report. The court commissioner yavat martira. There will be that this Saturday or Sunday. Court commissioner is directed to inspect that spot on 9th. What time? At 10:30. Both the parties and respective counsels can also present in the spot at 10:30 and assist the court commissioner. And court commissioner is directed to conduct a spot inspection on 9th and submit a report. When you will submit, Mr. Roy? Submit the report on or before 14th. Post this matter on 15th. Agoda? Yes. Learned counsel for the appellant is directed to pay that court commissioner fee of 25,000. Yes. Yes. 25,000. Yes. Appellant has to pay 15,000. Respondents has to pay 5,000 each. Yes. Only 25,000. Yes. Yes. Yes, you furnish that. The office is directed to furnish that copy to that advocates and the court commissioner. Yes. You also furnish the copies and assist in that both of them to identify that property. Let him. That is the only thing. Whether it is 12 or 13. Yes.
Number 28, excellent case for appellant Shobha Babikatti.
Twenty. 88. Yes, madam. Wants Passover. Or you want any date next week? Not tomorrow. Monday or Tuesday? Tuesday. Yes, leave this matter on Tuesday.
29, Varun Papireddy for appellant, Kevin Narasimhan.
Yes. Yes.
Appeal is against the order passed by the court.
Yes.
IA number 4.
Suit for FDP. Yes. Suit.
Respondent had filed a suit for partition.
Yes.
Respect of 68 properties.
Yes.
the suit was decreed holding that respondent is entitled for 2/3 share.
Yes.
Immunity is pending. Drawing up of final decree has been stayed.
Yes.
Matter is pending.
Yes.
The meantime, respond. The final decree proceedings in the court. The he filed an application, IA number 4.
No, that.
41
Hmm.
for appointment of the commission, the receiver.
Hmm.
Receiver in respect of item number 68.
Hmm.
But where the appellants have been carrying on business. Business. By holding the Excel.
No, now that item number 68 is also suitable property. No, let that commissioner submit a report. You carry out your business.
Receiver has been appointed.
Receiver has been appointed.
But this came up before your lordship. 23/1/2023. Has been stayed, subject to.
23?
23/1/2023.
Yes. Other to condition, the appellant herein has to submit an account of every month in respect of the property. Yes, are you submitting that?
Yes, I've been submitting. Now, Supreme order was granted of hearing the other side only.
Yes.
Now he has come up with an application for vacating the entry.
Yes, Mr. He is submitting. Yes. 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 Yes.
And finally, amount of profit manner was known. Hence, when I gave him an offer, you are only saying that there is 50,000 profit. I pay 1 lakh rupees instead of doing all this management, etc. That is the amount of profit that I have. I am ready to pay it. On 15/6/2023, manner segregation of mine was accorded to.
Yes, Mr. It is for benefit for you.
The risk of money.
They will give that to 1 lakh. They will deposit 1 lakh every month. Then in the partition, if you succeed, you will get a 50% of.
There are 3 shares. And for one of the second, they are for one of the second.
Yes.
One share to be given. The mother had executed a will in my favor concerning the 1 year. The scope of recruitment before the
Bill regarding it.
is not executed. In any manner, my share of money is always impact. Now, whether it is 50% is something other than they are taking. So,
Now that what are that other properties?
there are various movable properties that.
No, that first at least 1/3 you can decide first whether he can be accommodated that wine shop for him by calculation.
Because there is one findings that have been recorded based on the recognition. This is what my finding is done right from my father's side.
No, that is true. See, what is that income which is coming from that this thing wine shop? Similar value of the property can be granted to you. You can give up that. You want that wine shop itself. Then both of them can't be get. Then that if there is a dispute, then it has to be sold in that action. That is what the law.
It's a profit. Minus all those expenses.
Now you are saying that there is more than 1 lakh rupees. You calculate as in 1 lakh. Then you divided it by that other property.
No, there is larger profit. What I am saying is as an offer.
No, you offer that what is that maximum income which is there. If he is not accepted, you take that. That is that. See, both of them is offer what is the value of that wine shop. Who is offer more, they are entitled for the wine shop. Others is similar value of that property, they will take it. Why that dispute for the brothers? If in respect of that will it is proved, in 1/3 shares of the mother will goes to him. Otherwise, you get it divided in that. That is all that.
But in fact, 2 wine shops were taken in his name. License were taken in his name.
No, that is it that suit scheduled property?
But that was not included.
Then we are not. Why we are going not go beyond that?
he had disposed of both the shops.
No, that is not the issue.
Profit.
No, that is not the issue before that FDP court
Yes.
or RFA court or before this court. You don't go beyond that, what is there in that. Now that this wine shop is disclosed, one of them are offer for an highest rate, who will take that? Others will take that property, 1/3 you kept vacant for in the name of your mother. Who will succeed? They will get it. Matter ಮುಗಿಸಬಹುದು ನೀವು.
Look, disposed.
See, RFA can be restricted only in respect of the will, in respect of 1/3 property.
That is the only one. But I gave a proposal on the last occasion also to settle the matter. The dispute is.
No, see, you both of them sit together.
But he is claiming 66%. My claim is claiming 50%. The difference is only 16%. Therefore, we can sit together and.
No, even entire property you are seeking for 66, even mothers also.
Yes.
Then it's a fair that he is not.
Therefore, 4 cases are pending. We can set all 4 cases.
Yes, you with that wealth of ready, you can do it then. It's better.
I gave a suggestion, but if my learned friend is ready, we will sit together.
Sit together, the problem will arise only in that income of that wine shop. He will offering that it may 2 lakhs. Then you have to accept or give it to him, he will run it. That's the advice for you to your client. That is the better. When will you decide and inform?
This time may kindly be granted.
Fix that date. That is the only dispute now. Now
Yes.
you calculate that. What will be that? Now you can calculate anything. This will be that. What will be that increase of that income and all. Average you can come. You say that this is the value of this wine shop will be that 60 lakhs. You will offer him. If you say no, it is 60 lakhs, then you take it. You give up, you take that property's value, then you can do it. Yes.
Not-
At least you
not
can.
only property, there are other properties also.
No, that is what that.
Yes, can compensate that.
That is no. First, we have to value this wine shop. If wine shop value is 60 lakhs, then you can compensate by that other property. Person who is taking that wine shop will get in a lesser value properties in that other movable. That is how that it has to be calculated. Yes. 21. We'll have it on 19th. Which will be that? Yes, it will come on 22nd. Yes, 22nd. Yes, at the request of the parties, use this matter on 22nd. Interim order granted earlier is extended till next date of hearing.
Number 13, because it's for the applicant.
Yes. Okay. Yes. I asked that at 10:30. If anybody is there, I can give it by that government advocate was also there. You are not there. 6:30. I asked that I can give that orders by this thing. You can get 1:30 work, but ಮಾಡಬಹುದು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. You are not there now. It's already 12:30. Mr. 61, they are the members. Now there is already in a late. Already you have late for another 2 hours. '61. ಬೆಳಿಗ್ಗೆ government advocate, you communicate that order to that returning officer, Kolar alada, Oxcote. 1:30 you communicate. ಅದೇ ಅದೊಂದು ಬೆಳಿಗ್ಗೆ ಮಾಡಿದ್ವಲ್ಲ ಸೇಮ್ ಎಂಟ್ರಿ ಮಾಡ. Yes, you communicate them. If they are up to 3 o'clock, there is election. If they are eligible, let them vote it only for vote. Yes, you also communicate your parties, Mr. ಅವರು ಕಳಿಸ್ಬಿಟ್ಟು ಅದೇ ಸರ್ ಬೆಳಿಗ್ಗೆ ಮಾಡಿದ್ವಲ್ಲ ಅದೇ ತರ ಎಂಟ್ರಿ ಮಾಡಿಸ್ತಾರೆ. ಸೈನ್ ಬೆಳಿಗ್ಗೆ ಒಂದು ಮಾಡಿದ ನಂಬರ್ ಹೇಳಿ.
Number 30,
Respondents, 5, 6 to 20.
Yes. 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 No, you are a plaintiff or a defendant. Yes.
Initially, I had a benefit of it.
Yes. Why?
Total, there are 9 schedules.
Yes.
That leaving apart the all other schedules.
Yes.
Then second content, extra. So it's a dependent number 6. Have purchased the property.
Yes.
Therefore, property is not available. Therefore, the application is.
Now, where is that client? B. Now that who has executed that agreement?
Agreement for the first dependent.
First defendant.
Yes.
He has sold now.
She has sold. And it is agreement.
No, she has sold to whom?
Dependent number 6, 20.
Who are the 2, 3, and 4?
2, 3, and 4 are the husband. 3 and 4.
Yes. Yes, Mr. You don't create further litigation.
In the ordinary courts, I would have straight away accepted what my lord is suggesting.
Yes.
But here, my lord, the lower court has rightly looked into the fact whether the plaintiff has made out a prima facie case. If there is no prima facie case, my lord, the Honorable Supreme Court has clearly held that if there is no prima facie case, there cannot be an order restraining us from doing anything with our property. Now, my lord, for the prima facie appreciation, from page 66 onwards, the learned trial judge has passed a detailed order referring to the fact that the suit is per se only barred by law. There is no prima facie case made out.
Yeah.
Now, my lord, just in a nutshell, my lord, may I just submit? My lord, the agreement is dated 23/5/2020.
23/5?
2020.
Yes.
Now, my lord, the agreement is where he agrees to purchase 10 items for 16.5 crores.
Hmm.
He pays only 1 crore as advance and nothing more.
Yes.
Now, my lord, in the agreement per se, my lord, may I just pass on the agreement, my lord, the agreement has not been produced.
Yes.
My lord, may kindly see at page 2, page 1 are is the vendor.
Yes.
Page 2, kindly notice 1 BN Nitesh Purushottama. He is the confirming party. Now, why he is the confirming party? Because he had, if my lord would see the next document, document number 2 at page 8, he had a registered agreement of sale dated 5/3/2017 for sale of the property agreed to by the first respondent. In respect of all these properties, he has agreed, he is a registered agreement holder, which the plaintiff is aware. Plaintiff says, therefore, I will enter in you, the vendor, the confirming party, together will sell it to me. Confirming party, ironically, has not signed this agreement at all. So this agreement, my lord, is inquired for all purposes. It is not a complete or a concluded contract.
No, that Nitesh has separate agreement.
Earlier agreement, he is the agreement holder of the property, a registered agreement. My lord, this is an unregistered agreement, that is a registered agreement.
Yes.
Plaintiff, being the subsequent purchaser, is aware that there is a registered agreement in
But
favor of
there is no consent of that.
Nitesh Purushottam has not signed it. In fact, one of the preconditions, if my lords would see at page 4, para 5, balance, para 5, clause 5, my lord, the
Yes.
balance sale consideration of 15 crores 50 lakhs shall be paid by the purchaser at the time of execution, registration, sale deed before sub-registrar or his nominee. Rupees 9 crores 50 lakhs to the vendor, 6 crores to the confirming, but Nitesh Purushottam had paid 6 crores. That was to be refunded.
Yes.
Now, Nitesh Purushottam has not signed this agreement.
He is a party in this suit.
No, he is not made a party to the suit. Now, what happened, my lord, is the time is the essence of the contract and clause 12, your lordship should see.
Yes.
And 90 days is the time for the performance of the obligation. Now, my lord, from
Then nobody has filed Order 7 Rule 11 application for rejection of claim.
not yet, my lord, we were contesting, he had an ex parte order of temporary injunction. So we moved the court and said that this ex parte order of
temporary injunction restraining us from alienating the property cannot be held. The court will ultimately, you are protected under section 52 of 52. That's all, my lord. Okay. Purchasers are their risk.
I don't see when they should not alienate the lots. It leads to multiple stages. Why is the reason is this?
No, that's
I can see why I have not made a conforming party as a this. By the time I file a suit, Melons, he has Melons already received his amount. He cancelled the agreement. Therefore, there is no question of me Melons making him a party to the suit.
where is that cancellation of agreement? Yes. 52 of your
322 Melons. Their sale has been cancelled. Thereafter, they got registered. This will be done. Melons, what should be this? The moment the sale date cancelled, so the first agreement holder. I put it to the balance. I have a second agreement holder. I put it in. Therefore, the sale date should not have been executed in favor of not the defendant. But he was a conforming party, but the reason assigned by the first defendant.
yes.
Is that he has consented to receive his money back. It's not that he's going to execute the sale deed along with me. In fact, their sale deed he has not executed as a part of the sale deed as a vendor. Therefore, my learned friend contention that he would be a part of the consenting witness or together executing the sale deed in my.
Yes. Oh wow. What about that limitation? At the back end of the period of limitation, suit is instituted. Yes.
Which he has not received at time. Therefore, he must do the execution of sale deed. Therefore, time has passed. By conduct of the
Your vendor, who is appearing for that? Your vendor, who is that? You go on selling that and keeping quiet that is playing a. What is that?
After that, the purchaser now has settled with him, paid the money to him, cancelled it and then purchased the property.
Oh, why you are go on selling that property?
Because I got the agreement. There was a condition that we can settle the first agreement holder, take his consent and then come for registration of sale deed.
Where is that? You show that
That
condition.
is in the agreement, my lords.
Where is that?
There is no obligation upon me.
Let us see that he said.
In the agreement, my lords. Paragraph 5 and 6.
Which page number?
Page number 4.
Yes.
Clause 7
Yes.
specifically provides
Yes.
that the vendor and the confirming party shall execute proper intention duly casting the opposite sale agreement before execution of sale deed in favor of purchaser. Now, this was supposed to be done by him making the payment to him, getting it cancelled and then coming.
No, what is the time limit?
90 days. 90 days.
Where you have stated?
Paragraph 11.
The vendor along with the confirmed parties will execute the sale deed after you alienate the suit in favor of the purchaser by.
Time is the essence of the contract.
Yes.
Parties have been clear, unequivocal.
He has not paid that.
Issues are noticed to me in November 2020. I replied with that saying, I will give you time to January 31st. Please go pay, get it cancelled, get to and select it.
Yes.
He does not do that. He simply issues another notice to issue a rejoinder. I clearly state in the notice that if you don't do this, you will not have any rights to claim. He again ranges on that. And my lords, the main reason why the suit is filed is not because he wants to buy the property. My lords may kindly see appeal memorandum at page. Paragraph 13.
Yes.
He has listed out various amounts which is allegedly unpaid to him, which according to him amounts to 17 crores. It is all the sale consideration.
Yes.
Actually, the transactions are settled.
Yes.
But I hear now find the recovery suit against that.
Yes.
And his contention here is those amounts are sufficient to cause the sale consideration. Therefore, I am ready and willing. Not even an alienation will pay now.
Yes.
And ironically, the 1 crore advance which is paid has been returned to him. It has been returned, we still have the agreement is cancelled.
Yes.
Despite agreement cancellation, my lord, the law is well settled that when one's agreement is cancelled by a reply notice, the suit for specific performance per se would not lie.
he must seek a declaration that the cancellation of the agreement is bad in law. Such a declaration is not sought for. Yes.
And if not that you have not had the opportunity, my lord, when he issued notice, I have returned back to him saying, you are interested in it.
2008 Supreme Court. 2008 Supreme Court. The court below appreciates all these conditions and says, yes, you have walked in at a belated state, your conduct is certainly reprehensible.
And I last week, Henry also noticed one very important part.
Yes.
This sale agreement is, I am supposed to get 16.5. Logically, would I go and sell to somebody who is paying me lesser if he is ready and willing to buy my property?
Yes.
This is more an attempt to honest and try and recover some money which is barred by reputation. Right? Which according to me has already been paid back.
Yes. Yes, if any alienation they made, it is subject to the result of the suit. That is what the Supreme Court has also said. Please, please. See, specific performance. Ultimately, you can also entitle for that entire money with that interest. Which is also paid back. No, that subject to that he is accepting that. Ultimately, your interest will not affect. If you succeed, you will get back everything. No, that's when you have a prima facie case.
After exchange of legal notice, my lords, they sell the property in favor of
No, that is, see, no, their first burden is before entering into that agreement with you, they have entered an agreement with some person. They want to clear off that. Therefore, they have put a condition that you are not satisfied. Then there are two persons on their head. He is also asking their money. You have agreement given to you with that opinion that he will clear his that amount which he has paid. If you are not cleared, then he will demand from him. He has no.
When I should pay him.
Yes.
Even otherwise, if we take their argument.
Yes.
The balance in consideration of 15 to 50 lakh
Yes.
shall be paid by the purchaser at the time of execution and registration. Before the jurisdictional suffrages, sir.
That has to be done within 90 days. Subject to title deed.
This law is not getting to the confirming party because we have not signed this agreement. It is not getting signatures.
It is binding on defendant number one.
Yes,
To the
yes.
vendor.
Yes.
Because LEC minutes, page 3 minutes, clause 6.
Yes.
Now, where is the vendor minutes next? Para 6 minutes. So I read a para 6 minutes. That
Yes.
in terms of opposite sale agreement, 5-3.
Para 6 of?
Clause 6 minutes, page 3 minutes. Okay, agreement.
Yes, 6, yes.
That in terms of opposite sale agreement dated 5-3-2017, the vendor could not comply with her part of obligation and hence confirming party has expressed its intention to rescind the agreement. Subject to vendor recording the advance sale considered received by her in terms of said sale agreement to the confirming party. That is one of vendor's obligation. Now, whereas vendor with the consent of a confirming party has decided to sell the scheduled property in order to meet her immediate financial constraint and family necessity and thus approach the purchaser with offers the representation to offer to sell the scheduled property and purchaser has agreed to purchase the same subject to good and marketable title free from all income accusation and here attachment litigation charges and claims whatsoever manner to the total sale concern. Therefore, there is obligation on the vendor to give me a clear title. That is further. Last 8 minutes, next page,
Yes.
page number 5 minutes.
Yes.
The vendor shall make available for scrutiny by the purchaser or his nominee all original documents of title to establish that the marketable title over the scheduled property, including following related to the scheduled properties and furnish copies thereof within 30 days from today. They have to show that they have done this within 30 days. by intimating in writing that in regard hand over all the original documents of title pertaining to scheduled properties to the purchaser at the time of execution and registration. Sale date dated so and so, survey LSRT extract of relevant mutation entries, records of rights RTC from 1980, 81, up to date of the tax regime, all these. Have that done within 30 days.
I mean, within 90 days from today, there is no such condition that after that 90 days. You said from the date of agreement.
That is what my specific reading in my notes.
No, this is not the obligations of that conforming party. Conforming party's condition is that within 90 days you have to pay it.
Conforming party is never been part of this.
Vendor along with the conforming party shall execute the sale deed absolute alienation in favor of the purchasers or the nominee within 90 days from today.
Assurance by vendor to me that conforming party has accepted this, he will receive the amount and he will
No,
execute.
see, suppose if they are agreed that they will do it within 90 days, if they are not done it, can it be enforced? What is the law on that? Suppose even vendor, if they said that they have to furnish all these documents, ultimately sale deed has to be executed within 90 days. Can it be extended if, since they have not complied their part of that?
So because the suit filed by Merods and the confirming party was pending. Pending suit Merod, there cannot be a suit, sale deed to be executed. When that got Merods withdrawn, only on 3/3/2022, when the settlement arrived between vendor and Merods, the confirming party.
When that suit has been filed?
That was filed in Merods.
Huh? No, date of filing the suit. No, this suit has been filed when? 2022.
That too, my lord,
On 16 by
on 24/11/2020, the vendor in clear express terms says you have defaulted.
No, that I will come to that
No,
section.
no, why I'm only submitting
No.
this. After 2 years, the suit is filed.
No, that is what that, see, when that agreement has been executed,
23/5/2020,
23/5/2020. 90 days means
23/8/2020,
when the suit is filed. What is the limitation for filing the suit?
3 years, 3 years.
3 years.
But for the purpose of looking into the conduct as a plaintiff in a suit for specific performance, this gross delay, unexplained delay, would be looked into for the purpose of appreciating whether he is entitled for the claim of specific performance, prima facie or otherwise. And my lord, this.
No, that when you have cancelled that agreement.
When they said that
There was.
just check.
Wait.
Without admitting that.
In reply to the notice dated 24/11/2020, I specifically expressly stated that 90 days time is up. However, I am giving you time till 31st January to still comply. After that, you do not have any rights.
Where is that?
My lord, I have produced the reply notice on page 22, dated 20th February 2021. Oh, my lords may kindly see, every aspect is detailed. Kindly come to para 4 at page 23. May I read this paragraph? This will clinch the issue, my lord.
Yes.
My client reiterates that further time has been granted to you up to 31/2021 to refund the amount advanced by Purushotama as a loan and obtain cancellation of registered agreement to sell dated so and so in his favor, which your client has failed to accomplish. Mr. B.S. Neeraputra has now filed a suit against my client in OS 54 seeking specific performance of the agreement dated 5/3/18 and other consequences before the principal senior civil judge Ramnagara, and has also been granted an order of temporary injunction against alienation till the next date of hearing. It was specifically
Yes.
specified in the reply dated 24/11/2020 that after the expiry of the said period, all understandings, agreements, etc. between my client and your client would stand annulled without any further acts, and my client would be at liberty to deal with the property as she deems fit. This is emphasized on 20th of February 2021.
Yes.
And yet he does not issue the suit.
Yes.
He waits.
When it is alienated to you?
3/3/2022. It's only after it is sold to me, he wakes up.
Yes, what is the finding of the trial court?
Lord, from page 66 onwards, in detail, the learned trial judges, page 65 onwards. B.
Yes.
Para 56 refers to the same.
Yes.
Kindly come to page 71. Page 71.
Yes.
The para 70. Para 69, I'll read.
Yes.
In this regard, during the course of arguments, the learned counsel for the first defendant has argued that at the outset there is no agreement in the eye of law which is capable of being enforced by the plaintiff at all, since the agreement dated so and so does not bear the signature of the confirming party, my lord, at the cost of repetition, it's an inchoate document. For all purposes, it is not a concluded contract.
Yes.
Because the confirming party, who is a pivotal party to the scene, at that point of time, is conspicuously absent and not signed the agreement.
Yes.
And later on, he files a suit for specific performance,
Yes.
all the more reiterating that he has nothing to do with the transaction that the first defendant had with the plaintiff. Then another para 70, that another serious lapse on the part of the plaintiff is that he and it is put the show the mark, who is admittedly shown as the confirmed party in the sale agreement, is not made a party to the present suit. Therefore, the obligation of executing sale deed was not only on the part of the first defendant, but also on the part of the confirming agreement. That the sale agreement was entered into with an anticipation that the confirming party would sign this agreement. However, sale agreement is not executable since the confirming party did not sign it. Next. Moreover, the conduct of the plaintiff is also found at fault in view of the deficit stamp duty paid on the sale agreement dated so and so till the date of filing on the suit. Moreover, there is no explanation offered by the plaintiff as to what he did since 2003 till the date of filing the suit. That is, that there is absolutely no prima facie made out by the plaintiff to establish he has a tribal case. Now, in the aforesaid agreement canvassed by the learned counsel, it is necessary to admittedly, as on the date of entering a stamp duty only rupees 500 was paid. Then, my lord, no doubt, prior to the filing, plaintiff has paid it. So he also wakes up at the last moment, rectifies the defect in the stamp duty, and then comes. Then, my lord, kindly come to para 76 and page 73. Para 76.
Yes.
However, as far as the present application is concerned, as could be seen from the materials available in record, it is clear that though the first defendant as well as the confirming party issued reply notices, immediately after receipt of the notice got issued by plaintiff, the plaintiff has not shown any diligence to take further steps in the matter. Therefore, as per reply issued by the plaintiff, first defendant 24 plaintiff, she has proceeded to transaction with the defendant 6 to 10. What I read from my lord's consideration, the reply notice. Moreover, even in the reply notice dated so and so, the first defendant's categorically made a stand clear that as the plaintiff failed to comply with the directions issued by her in her reply notice, he has absolutely no right to demand execution of sale deed in his favor. Now, as per the documents produced by the counsel for the plaintiff, it is clear that already suit item number 2, 4 to 9 have been sold in favor of defendant 6 to 20 through a registered sale deed. And as per said document, it appears that as on the date of suit ownership are neither the ownership nor in possession of defendant. My lord, I will pause for a moment here. Item number 1, suit schedule property, which is subject matter of the agreement, ironically, was even acquired by the KADB on 19/12/2019, even prior to this agreement. And yet the plaintiff ventures into buying that property which is acquired and vested in the KADB. Number 1. Item number 3, suit schedule property, my lord, is not sold to defendant 6 to 20, but to another third party, who is not made a party to the proceedings.
Yes.
That is what is observed. Now, as my lord, in this regard, the defendant 62B is that item number 1 was acquired by KADB, and hence suit in respect of item does not survive. That there is no way concerned, they are in no way concerned with item number 3 suit property, since the same is sold to some third party who is not made a party. Therefore, according to them, they are bona fide purchase of suit schedule items 2 to 4 of 9 properties for valuable consideration.
Yes, we'll say that any alienation is subject to the result.
Please.
You are taking notice to whom?
Lord, defendants 6 to 20 millions. Siddharth Suman has filed Wakala, but it's not shown.
No, you are taking 6 to
6 to 20. Siddharth Suman, Lord Advocate on
Yes,
record.
notice to 1 to 6 as to 1 to 5. You are taking 1 to 5. So and so is undertake to appear for. What is Agidya? First time again.
First, give it.
Aviator. P. Srinivas. Undertake Learned Council P. Srinivas, aviator for R6, undertake to appear for 1 to 6.
Siddharth Suman undertakes to appear for 6 to 20 along with KVT.
Yes. Siddharth Suman has undertake to appear for respondent number 6 to 20. U.G. Sridhar. Sridhar is undertake to appear for respondent number 1 to 5. If any alienation of the suit scheduled property by either of the parties is subject to result of this appeal.
Please.
Yes. Yes.
Okay, your lordship is restricted to work this matter at 2:30 p.m.
2:30 will hear. You come at 2:30. Yes, 2:30. Yes.
32 A.M.
Yes. Yes. What is IA1 of 2023? There are two IAs you have filed for. Yes. IA1 of 2023 filed in a memo for dismissal of IA1 of 2023 as not present. Hence, IA1 of 2023 is dismissed as not present. Yes, what is this mechanism? Yes. Yes. Yes.
Third one, that was advanced by
Yes.
an application under 39 rules for 15th month. I
Yes.
filed objections to the 39 rules for application and I sought for 2-year application, year-long application. The court below, without considering the same, holding that granting of itself is wrong, like that, not say anything at all. Simply so much vacated the interim order, posted the matter to year.
Where is that order?
Last year, kindly go to page number 17, page number 17.
Yes.
I read out for a last case. Advocate 2 to 4 has filed a memo with photos. 90 has filed a present suit against the defendant one, the executed of the sale agreement. The deed 2 to 6 are not the parties to the agreement. There is no pleading in the whole claim how they are the parties to the suit. Hence, the extension under granted is hereby vacated. The line 20 said a filed objection to for here in the IA number 103. The interim order is vacated.
What is that interim order granted?
Not to alienate the interim order.
Yes.
Not
Issue notice. Parties are directed not to create third party interest in the suit schedule.
IA filed by me is not to put up any further construction.
Parties are, then you maintain status. Yes, parties are directed to maintain status quo in respect of suit schedule property. Yes, till next date of hearing. Issue emergent notice. Yes.
Is one for declaration and mandatory election and for calculation of the city's property.
Yes.
But case of the plaintiff is not the social property is purchased by him.
You are a plaintiff or a defendant?
Blood and the plaintiff.
Yes.
39 is filed.
Yes.
Restraining the defendant from putting up construction stuff.
Yes.
And earlier, the election order was granted in favor of the plaintiff.
Yes.
Subsequently, by due order,
Yes.
the same is vacated. But my submission is respondent number 1, 5, 14, and 15. That I've already started putting up transactions. Without obtaining license, it comes under PBA.
Yes.
Without obtaining license or plan set.
Yes.
Rest all other persons, they are not putting up any transaction.
Yes.
Therefore, you are rightly, the High Court will not start. Many of the savings used by the defendants
Yes.
are subsequent to the savings of the plaintiff. 2019 is the plaintiff salary.
Yes.
He purchased five acres of land and also 8 acres of land in September 48. There are 3 reasons are assigned to dismiss my application. Number one, I have purchased agricultural land. The social property comes within the BBMP limits. Therefore, the court says that it should be over in agricultural land. Number one. Number two, the defendants have already started putting up construction. And since they've already putting up construction, I have sought for portion of the property. That the court says that
ಇದು ಬೆಳಗ್ಗೆ ಆಗಿದ್ದು 16 ಸರ್.
Yes, Mr. No, only you are seeking a restraint not to put up construction. Yes, Mr.
Construction, respondent number 1, 5, 14 and 16, 15. Let them carry on subject to result of the suit. Others will not, they will be restrained.
No, we cannot permit them to carry on that without their license. We are permitting that to carry without, they are having in a license and all, I will permit them to continue. That is all subject to result.
They have no license.
Let us see that. Now, what will say, stay up further construction. If you are already constructed, it's good. Person who is under construction, let them show that they have any license and all. I will permit you to construct, but not to alienate or create third party interest. Yes, now that you come to that judgment and degree, page 22. 22. That is defendant number. Huh? I am not deciding the title. Let it. Wait, I will hear you. First, let him finish. I will hear you. Your impugn order, judgment and degree. Your defendant number 1, 2, 3 and 5 and 10. No, ಅದರಲ್ಲಿ ಯಾರ್ಯಾರು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ 1, 2, 5. 1, 2, 3 and 5 completed construction. Yes, he has to, yes. Then, no, if they have obtained the permission and all, if they are in the position, let him construct, not to claim any equity. Tomorrow, suppose if he fails, he will compensate all the loss which has cost. Person who has in the possession, obtain the permission, let him construct. You will get that constructed house. Or if you don't, if you want that vacant place, if you succeed, you will give that vacant place after demolition. See, the problem is, if you make some litigation, person who has invested so many monies and he has borrowed that money, admittedly he is in the possession, license has been obtained, nothing wrong in them to permitted to construct, but should not create third party interest if there is any dispute.
My submission to the lordships is this.
Yes.
Admittedly, that earlier, that only 194 of 16 suit was filed by first respondents vendor against my vendor.
Yes.
That the suit is dismissed in the year 18.
Yes.
That in spite of dismissal of the suit, that they sent it to be present first respondent.
Yes.
And that she started putting up concern. Now I have filed declaration. Of course, madam. My only.
They have obtained that permission from the competent authority that nobody is challenged. We'll see that, we'll see, protect the interest of all the parties. We'll see now that what is your case, Mr. You are appearing for whom? Respondent number 15. That is defendant number 15. Yes.
Yes,
You have completed construction. Yes. Yes. Here is that earlier order in which case? ಅದೇ ಯಾರ್ದು?
ಆ ಸ್ಟೇಟಸ್ ಇರ್ಬೇಕಾದ್ರೆ ಕಟ್ತಾರೆ.
ವೈಲೇಟ್ ಆಗಿದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿ.
That we are doing it. And the neighboring owners also.
See, status quo in respect of all suit scheduled properties is already there. In that case. Yes.
Already there, we're not in spite of that. They started putting up.
Yes, yes.
Not my only submission would be whoever already started putting up construction, not let them go in accordance with law. Whoever has not started law, in order to avoid multiplicity of proceedings, to dispose of the suit at an earliest point of time. Because I claim under a SELI.
No, who is appearing for? No, now he is appearing for 15. What about that other respondents? You are appearing for whom, Mr.
Only KV trust.
Then notice has to go to that. R6. 6 and 7, what is the status, Mr.? No, see, whoever there in that possession, who have obtained that license, let them construct. Who already constructed, construct, but not to create third party interest. One thing. Second thing is that other respondent is not served. I can't dispose it, Mr.
Interim order will be passed, but except and take a servant in the high court also.
You file a rejection of line. All that is there. Yes. Yes.
It's not even converted now. They have done SELI as per SELI sites.
No, now that defendant number 1, 1, 2, 3, 1, 2, 3, 5. 1, 2, 3, 5. And you are 10 now. 1, 2, 1, 2, 5. 1, 2, 3. Alala. Complete. 1, 2, 3, 5. 1, 2, 3, 5 and 15 also. Yes. Defendant number 1, 2, 3, 5 and 15 are directed not to create any third party interest. In who is under construction?
6 and 7.
No, it's vacant set, they are not.
6, 7 and 10. 7 and 10.
6, 7 and 10 they are constructing.
No, madam, they are not.
Wait. Where is that? You show that. Where is that obtaining that plan and all?
No plans for.
Then we'll have it Monday, Tuesday.
But they would also.
No. Without plan, they can't do it.
Then madam, anyone will. Because in the.
Tuesday.
Tuesday.
Wednesday, better. Tuesday.
Tuesday.
Yes, 12. You produce that plan, then we'll permit it. Yes. Reach this matter on 12.
34 that will be on for appellant S.G. Muniswamy Koda.
Order and better. There is 13th. Pass off. Yes, madam. He wants pass off. Any inconvenience? No, usually the practice in the High Court is once we'll pass over. Unless you have any inconvenience, if you want any date, if he has no objection, we'll grant that. What is that? Any urgency? You could have informed that senior counsel that we are going to take pass over. Yes, any other date you want? Yes, when do you want? Not tomorrow, Monday. Monday. Yes, use this matter on Monday. Yes.
Number 35 Shiva Prasad for appellant.
Yes. 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 Shoot for? Yes. You are the plaintiff.
I was in number 1.
Yes. 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 What is that? What is that interim order passed?
Page 48.
Yes.
Expertise have been granted. The first defendant, that is with the petitioner,
Yes.
or any person, they will- like that, to be restrained. Expertise order, application that expert also, given it understood in this.
Yes. You.
It's on alert, 20. This the registered sale agreement will not be the parties. It will not be different number 1 and 2.
You are creating third party interest. Where is that sale deed? Who has executed that sale deed? Yes. 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 That where is that this thing? Actually, yeah. No, sale deed, the plaintiff is a party.
Yes, it's 90 sale deed.
Where is that?
78 sale deed.
Yes.
Page 1 of 11 of the same. But it is pursuant to the GP executed between the parties.
Yes.
The GP alert is in the exact HLC page 71.
Yes. So notice any alienation of the parties of the suit scheduled property is subject to result of this appeal. Yes.
Number 36 executive for appellant.
36, yes. Yes. Yes.
Application method.
Yes.
With the plaintiff.
Yes.
Stating that when an application of produced along with the list of
Yes.
plaintiff is the prayer in the application.
Yes.
Court also noticed the fact and the bond by the email. The court demolished the building and the credit.
No, suit for
Suit for the declaration and injunction.
Declaration and injunction, what mandatory injunction?
No mandatory. Empty injunction.
Injunction. Now, how can they seek for this?
Prayer injunction prayer demolish the building and the
Now that is granted.
Judge says, no, I cannot grant as a prayer, but I will grant injunction.
What is that injunction?
That shows that building is there.
Yes.
And then necessarily it's a defendant. After the
Yes. Now you maintain status quo. If you are there in the position, now you.
let's stay at that order.
Why? No, if you,
Otherwise, you can the status must be proved.
where is that they're seeking for demolition?
Kindly see the application. I have an injunction. I have produced along with the documents. These are documents.
Yes. List of documents, application under order 41 rule 5 ada. List of documents.
Documents extra.
Yes, sir. Hakidhi,
Page number 1 ಅಲ್ಲಿ ಅದಕ್ಕೆ.
Hmm.
Otherwise, so on so these to issue attended injunction preventing the defendant in license but demolish the compound and shed constructed therein or in any way demolish ಮಾಡಬೇಕು ಅಂದ್ರೆ it shows that defendant is in possession. Now I have produced the electrical bill. It shows my name. Page number 11.
4th July 2023. Stay of order dated 4th July 2023 passed by 24th Additional City Civil and Session Judge, Bangalore, in YS number 274 of 2022 till next date of hearing. How do you notice first? Yeah.
Only place for appellant.
Yes, Murali.
Defendants in the bill. Partition and separate possession. Final rated hotels.
Yes.
Because it is quite a trial court. More than 3 grounds.
Yes.
But appeal was filed in the year 2020. But after submitting not 2 applications for filed.
Yes.
One under order 1617 seeking amended claim. And the other one not to produce an additional evidence. But the learned applicant did now not without looking into the.
No, that you are a plaintiff or a defendant.
I'm the defendant.
The suit is dismissed or decreed. Suit for
Partition.
partition is dismissed.
Is dismissed.
Then they have filed an appeal.
Yes, sir.
What has happened to that appeal?
But in that not now allowed the impute on under the impute judgment and decree. Matter is remanded to the trial court.
Where their own cost so order CPC is hereby allowed additional documents filed under court. Yes. Hard issue notice stay of further proceedings in YS number 90 of 2016 pending in the file of second additional city civil judge JMFC Shimoga till next date of hearing. Issue emergent notice.
38 exempt for petitioner Indrakant Argole.
Yes, but yes, he wants time, Mr. Ivan. Yes, or the request of counsel for the respondent, release this matter next Thursday. Next week under next Thursday and tell it. Yes.
Number 39 Manjunatha V. Rayappa for petitioner Sridhara K.
For responding.
Not proceed. Trial court already.
That's out against the 2 and 3. You want to dispense or you? Yes, learned counsel for the all right 2 and 3, you know. Petitioner prior 2 and 3 na. Yen office objection idya.
Office objection regarding limit application filed.
IA 1 of filed amendment filed by the advocate for non-filing of acknowledgement having paid that balance amount 5 months arrears.
They want to file.
Huh?
Pay minute. 6 months they are not paid. Okay.
My submission.
Yenado.
My one submission. In series number 238 of 2012, they filed the execution petition. In that petition, the respondent already paid the amount.
I will come to that. Wait. IA 1 of 2023 for amendment filed by that advocate for the petitioner. What is that amendment you are?
Date of the filing, we are sought for the maintenance. Order is date of the order. That is the-
Amendment ಅಲ್ಲ ಹಾಕ್ಬೇಕಲ್ಲ ಇಲ್ಲಿ ಯಾಕೆ ಕೇಳ್ತೀವಿ ಇಲ್ಲಿ amendment of that judgment you are seeking.
Direct the respondent, my prayer.
No, that cannot be. If there is any direction from there we have to seek for an amendment. Or if you here, if it is allowed, then we can direct it. That is different. Now you can't seek that this thing. Petitioner is entitled monthly maintenance 10,000 from the response from the date of this order. Yes. Ada ye bidi. Non-filing of acknowledgement having paid that balance amount. Yenadu yaro?
See, Miss number two, yes, see, Miss number 230 and 2012 already paid, my lord.
Wait, what is this matter, Mr.?
Petitioner, one filed the maintenance before the trial court. The maintenance.
You are a
I am the wife, my lord, wife. Hearing the matter, trial court and consider the other documents that was the issue not.
ನೀವೇನು ಎನಾನ್ಸ್ಮೆಂಟ್ ಹಾಕೊಂಡಿದ್ರ ಜಾಸ್ತಿ ಜಾಸ್ತಿ ಬೇಕು
Marriage, married daughter is there. Not asking you. Yeah, the respondent is the government servant, my lord, she is.
that ಎಲ್ಲ ರೀಸೆಂಟ್ ನೆನ್ನೆ ಮೊನ್ನೆ ಎಲ್ಲ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದಂಗ ಆಯ್ತಲ್ಲ ಆಫ್ಟರ್ ದ ಮೇಜರ್ ದೇ ಕಾಂಟ್ ಎಂಟೈಟಲ್ ಫಾರ್ ಮೇಂಟೆನೆನ್ಸ್
That's the different, that is the mother is a working teacher.
somewhere I have seen that judgment online somewhere to we
Before yesterday passed under Justice Rajan Palam.
they are not entitled after major.
I am not asking if daughter and myself, enactment.
That will see that wife that what is that your husband is doing.
Fireman department driver, my lord, driving salary 60,000 per month.
ಏನ್ ಎಷ್ಟು
60,000.
60,000 ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
They did not produce. my lord.
then how can you say that 60 what is that trial court considered?
On the basis of 50,000 gross salary, trial court considered.
ಎಲ್ಲಿದೆ ಫೈಂಡಿಂಗ್ ಎಲ್ಲಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್? Is that consideration of trial court mission?
Page number 18.
Page number?
18.
Yes, Mr. What are you doing?
Yes, my lord, is kindly peruse the prayer made by the petition in petition, please, sir. Prayer, ma'am. To set aside the impugned order dated 5/9/2022 passed by the principal family judge Shivamoga. Second one, to pass an order to pay maintenance charges 10,000 per month for the petitioner number 2 and 5,000 per month for the petitioner number 3, my lord. Kindly peruse the impugned judgment page number 24, my lord. Page number 24, my lord. Para 10, my lord. During the course of argument, the counsel for the petition filed a memo to dismiss the petition of the petition number 2 and 3, stating that they are majors. Hence, the said memo is accepted and dismiss the petition of the petition number 2 and 3. In the trial,
Now he is also filed in a memo that he will not press for petitioner number 2 and 3. Is this, Mr.? That is also memo.
yes, ma'am. The petition itself is not maintainable, ma'am.
By in respect of the wife, he is claiming.
Wife is claiming the wife satisfied. 10,000 amount of she is residing in the husband house. 10,000 has been hard earned.
Yes, Mr. What is
And that's
in prior ಆ ತರ ಕೇಳಿದಿರಲ್ರಿ
I that's meant sought for enactment.
ಎಲ್ಲಿ ಕೇಳಿದಿರ
Honorable court.
ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕೊಟ್ಟಿರೋದನ್ನು ಸೆಟಿಸೈಡ್ ಮಾಡ್ರಿ ಅಂತ ಕೇಳಿದಿರಾ
Amendment application.
ಇಲ್ಲಿ
Amendment application enactment ಗೆ ಹಾಕಿದ್ರೆ A1
ಆಯ್ತು ಬಿಡಿ ಪ್ರಯರ್ ಆಯ್ತು ರೀ ವಾಟ್ ಇಸ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ಡೂಯಿಂಗ್ ಮಿಸ್ಟರ್
Fireman, ma'am.
ವಾಟ್ ಇಸ್ ಇಸ್ ಸ್ಯಾಲರಿ ವಾಟ್ ಇಸ್ ಇಸ್ ಇನ್ಕಮ್ ಮಂತ್ಲಿ ಇನ್ಕಮ್ ಸ್ಯಾಲರಿ
I will ascertain, ma'am. I will
ಯು
ascertain.
ಪ್ರೊಡ್ಯೂಸ್ ದಟ್ ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್
Please, sir. Please.
ಎಸ್ ಈಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ when will you produce
2 weeks time, ma'am.
counsel for the respondent is this matter and 26 yes
Number 40, Raghu ML for petitioner.
yes Yes. Your wife or husband. ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಅಂದ್ರೆ ಎಷ್ಟ್ ಜನ? 2, 1, 3, 3, 7, 10,000. What about that 2 and 3? Yes. Or issue notice. Yeah. Order dated 17th December 2022, subject to condition that petitioner has to deposit 50% of that maintenance, arrears of maintenance amount awarded in favor of petitioner number 1, that wife, and deposit entire arrears of the amount in respect of 2 and 3. And directed to pay 3,000 each to petitioner number 2 and 3 as a monthly maintenance. In respect of monthly maintenance of petitioner number 1 is paid. Directed to pay that arrears of 50% of the arrears of the maintenance granted to petitioner number 1 within 2 weeks. ಅಲ್ಲೇ ಪೇ ಮಾಡಿ ಅಲ್ಲಿ ಪೂರ್ತಿ ಕಟ್ಬಿಡಿ ಹಂಗಾರೆ ಅರಿಯರ್ಸ್. Yes, he has directed to pay 50% of the arrears amount in respect of maintenance payable to petitioner number 1, that is Srimati Rupa. ಅವ್ರ ಮಕ್ಕಳು ನೀವು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಲ್ಲ. No. You pay that children full. Yes, in respect of petition number 2 and 3 is directed to pay entire arrears of amount before that before the trial court. In execution petition. Directed to deposit 50% of that before the criminal petition number so and so on next date of hearing, and deposit entire dues in respect of petitioner number 2 and 3 before the same court in next date of hearing, and is further directed to pay 3,000 each monthly maintenance. That order dated so and so stayed only in respect of monthly maintenance payable to petitioner number 1, that is wife Srimati Rupa. Subject to condition, he has to deposit 50% of that arrears within 2 weeks. Before that, so and so forth. Other than yes, issue emergent notice. In addition, petitioner is permitted to serve a copy on the counsel appearing for the respondent before the trial court. Yes, you give that summons to them. Yes. Yes.
Challenging an order of interim maintenance under section 55. The last occasion when the Lord please to say the impugned order subject to deposit of 50% of the arrears that has been done not on 1/9/2023.
Why it is posted today then? You have moved the Yes, where you have deposited within. Then you file an memo.
And must be filed in the registry also. about that.
Yes, you file it. Yes,
Yeah, there have to be word.
you file an application for releasing master. We will permitted you. Yes, yes. Next week, you file an application of that, not memo. It's why affidavit has to be filed that. Then we will permit it to release. She is also no objection. Only thing is that application is not there. Next week, yes. Yes. Interim order granted earlier is extended till next date of hearing. Alre, ನೀವು ಈ ನಂಬರ್ ಅಲ್ಲಿ ಹೋದ್ರೆ ನಮ್ಮ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಇರ್ತದೆ ಡೀಟೇಲ್ಸ್ ಹಾಕ್ಬೇಕು ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ನಾವು ವಿಲ್ ಪರ್ಮಿಟ್ ಟು ರಿಲೀಸ್ ಎಸ್ ಎಸ್
Matter serial number 42, Om Prakash BV for petitioner, government advocate.
yes Mr. It's become in
They said the election has been fixed. The calendar events.
now they are given.
Next week, after we conducted for the year,
Election is over.
They said that they give.
On that day election has held.
No, I think the board. I think the proceedings, not election proceedings.
No, election ಪ್ರಕಟಣೆ ದಿನಾಂಕ 21ರಿಂದ ಮುಂದಿನ 5 ವರ್ಷದವರೆಗೆ ಈ ಕಳ್ಕೊಂಡ ಅಭ್ಯರ್ಥಿಗಳು ಅವಿರೋಧವಾಗಿ ಆಯ್ಕೆ ಆಗಿರ್ತಾರೆ. This is an election result, Mr. Who has all elected. Elections.
My society is not at all there in this. My society is Radhakrishna society. Something.
Where is that Radhakrishna society?
Not that is for secondary society. He is conducting from the primary society. Not.
Secondary society election is conducted, he will lose that this thing, primary this membership. But no, he is must direct the respondent to appoint that election officer to the petitioner society to conduct that governing council member directed to election as per that petitioner representation annexure C, which is that petitioner society. Radhakrishna House Building Cooperative Society. Radhakrishna House Building Society election ಆಗಿದೆಯಾ? ಬೆಳಗಾವಿ ಯಾವ್ದಾದ್ರು ಬೇರೆ ಬೇರೆ ಇದೆಯಲ್ರಿ, ಬಿಜಾಪುರ ಜಿಲ್ಲೆದಿದೆ. ರಾಧಾಕೃಷ್ಣ ಹೌಸ್ ಬಿಲ್ಡಿಂಗ್ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಯಾವ ಊರು ಇದು? ಇಟ್ ಇಸ್ ಇನ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಮಿಸ್ಟರ್. ಇದೆಲ್ಲ ಹಾವೇರಿ ಯಾವ್ದಾದ್ರು ಬೇರೆ ಬೇರೆ ಇದೆ, ಹಾಸನ. Yes. Government advocate prays further time to get instruction in this matter. Please this matter. Election ಆಗಿದ್ರೆ ಇನ್ಯಾಕ್ ಮಾಡೋದು? ಎಲೆಕ್ಷನ್ ಆಗಿದೆಯಾ ಇಲ್ಲ ಅಷ್ಟೇ, ನೀವು ಆಗಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟು ಕಂಡಕ್ಟೆಡ್. Yes, please this matter on Monday. Next Friday. Yes. ಅಷ್ಟೇ ನೀವು ಫೋನ್ ಮಾಡ್ಬಿಟ್ಟು ಎಲೆಕ್ಷನ್ ಆಗಿದೆ ಅಂದ್ರೆ ಐ ವಿಲ್ ರೆಕಾರ್ಡ್ ಯುವರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂಡ್ ಕ್ಲೋಸ್ ಇಟ್. ಯಾವ್ದೋ ಬೇರೆ ಸೊಸೈಟಿ ತಂದಿದ್ದಾರೆ. ಐ ಹ್ಯಾವ್ ರೆಡ್ ಮಿಸ್ಟರ್, ಬಟ್ ದೇ ಹ್ಯಾವ್ ನೌ ದೇ ಇಸ್ ಪ್ರೊಡ್ಯೂಸಿಂಗ್ ದಟ್ ಅದರ್ ಸೊಸೈಟಿ. ಇಟ್ ಇಸ್ ನಾಟ್ ರಿಲೇಟೆಡ್ ಟು ದಿಸ್. ಎಸ್.
Serial number 43 adjourned, serial number 44, B.L. Sanjeev for petitioner, government advocate.
Yes, yes, Mr. What is this?
Elections.
Yes, Mr. Government Advocate, you take notice. No, AGFR notice is already ordered.
Election next year, 132 proceedings should be from the register will not that is not valid at 230.
No, that let us see what is.
There are these are the petitions that are pending before the respect of that society not. It has issued the direction that can be the spirit does not be great husband to the pending. It is because of that reason of the next year.
File an objection. whether you have such a power to not to alienate that property. Can you issue a direction not to alienate that property? You have the such power under section 30. Yes. Government advocate is placed 2 weeks time to file an objection. Let him file an objection. No interim prayer. Yes. No, then we will have it on Tuesday. You get that instruction. Not let it be before regular pitch. That they have to get an instruction whether they have a power or not. Yes.
Next matter, serial number 45, Vinayaka BV for petitioner.
Yes. Yes. Serial number 54. Yes.
It's a very short point.
Yes.
Every district, federal, there's a secondary society will have a representative from the taluk. I mean, so far as Chikballapur and Kolur taluk is concerned, there is one DCC bank. Earlier, there were 12 taluks. The previous election, or present election, now it has become 14 taluks. 2 new taluks are included. That is Chedu taluk and Mancherali taluk. So earlier at our Gauri Bithur and Bagipati, only those societies, primary societies, which come within the purview of taluk. Taluk is not defined under the bylaw. Taluk essentially means the taluk has defined under the revenue or the revenue jurisdiction. Now, the primary members coming within the jurisdiction of Chedur and Mancherali will not fall into any other taluk. Remaining 12 taluks, they are entitled to elect 1 member each.
Yes.
This was the situation. So representation was given, and thereafterwards the matter was placed before the general body. General body said there are 2 things which requires to be amended in the bylaw. Number 1, there are 2 nominees of the government which is contributed 28A, therefore we will have to amend the bylaw number 1. Secondly, since 12 has become 14, and there will be the members, primary members who are now come out of the voting pattern because of the constitution of new taluks, they will also have to be included by 2 taluks, and therefore they will also have to be included. This was the resolution which was put forth before the general body. It was required to put to vote. There was a unanimous decision that let it take place. But President unilaterally says, I have some pressure. I don't want to take a decision on this, therefore I am deferring this the decision of this matter. Matters to defer at that. But he observed that if need arises, we will call for a special general body meeting and take a decision. This is where things stands. Now, so far as election process is concerned, it is deemed commenced because of the Cooperative Societies Act. From 6 months from the date on which the elections is required to be conducted or the previous votes term will expire, process starts.
Yes.
Now they have to first take a decision. The general body has to be called for. All these amended bylaws will have to be given effect to. In such that the elections cannot be conducted. You cannot exclude the members from conducting the election. That's all the point.
Yes, madam. Yes. Yes.
The resolution of the
Page. Yes.
On 12/8/2023.
Yes.
But the 11th page was page 31.
Yes.
It's the subject of the AD.
Yes.
It was the Kolar event.
Yes. Now you are reading that
Page 31.
31.
Page 31. Yeah,
Yes.
that's the subject.
Yes. Yes.
Last 6 lines.
Yes.
ಈ ಕಾರಣಗಳಿಂದ
Yes.
ಈ ಕಾರಣಗಳಿಂದ ಎಲ್ಲಾ 14 ತಾಲೂಕುಗಳು ಸಭೆಯಲ್ಲಿ ಭಾಗವಹಿಸಿದ ಎಲ್ಲಾ ತೀರ್ಮಾನಿಸಲು ಸಭಾಧ್ಯಕ್ಷರು ಈಗಿನ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ಹಲವಾರು ಒತ್ತಡಗಳ ಕಾರಣ ಹಾಗೂ ಇತರ ಉದ್ದೇಶಗಳಿಂದ ಅಗತ್ಯವಿದ್ದಲ್ಲಿ ವಿಷಯಗೊಳಿಸಲು ಈ ಬಗ್ಗೆ ತೀರ್ಮಾನಿಸಲಾಗಿತ್ತು. ಈ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸುವ ಅಗತ್ಯ ಕಂಡುಕೊಳ್ಳುತ್ತಿಲ್ಲ ಎಂದು ಅಭಿಪ್ರಾಯ.
No, that when there is an agenda, If president says no, it is not no, it is on majority.
Minority, lords, the presiding council has no jurisdiction to say that once the majority has decided that I will defer the decision, the majority has already taken a decision. If you're not so to see.
No, now that resolution has to be passed on the basis of the majority.
So resolution is already there. While recording the resolution,
Yes.
it is referred that ಸಭಾಧ್ಯಕ್ಷರು ಮಾತನಾಡುತ್ತಾ ಈಗಿನ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ಹಲವಾರು ಒತ್ತಡಗಳ ಕಾರಣ ಇನ್ನಿತರ ಉದ್ದೇಶಗಳಿಂದ ಮುಂದೆ ಅಗತ್ಯವಿದ್ದಲ್ಲಿ ವಿಶೇಷ ಸದಸ್ಯರ ಸಭೆಯನ್ನು ಕರೆದು ಈ ಬಗ್ಗೆ ತೀರ್ಮಾನಿಸಬಹುದಾಗಿದೆ.
No, he alone can take a decision. Then question of calling that meeting would not arise.
This itself should be taken as a resolution and the amended bylaws will have to carry on page 19 of it has some relevance.
You take notice to whom? You will take 1 and 2. Government advocate is directed to take notice 1 and 2. So and so is directed to take notice for respondent number 3. When do you want? Not tomorrow. Tuesday.
Tuesday.
Release this matter on Tuesday. Yes. Before all same.
Just not that this matter will listed in the
Same preliminary hearing. Yes, Tuesday in preliminary hearing. Yes. In serial number, yes, 54 only. 1 and 2, government advocate. So and so is directed to take notice for respondent number 3. Post this matter on Tuesday in preliminary hearing. Yes. Yes.
So
Yes. Oh, I got it. Yes. What is this serial number 46?
number 46, I am appearing for the petitions. So post all stated in the board of directors. It done as on that date is 4th and half. Then election should be conducted, or otherwise the board has to go out. Conduct the election 6 months is fixed under the rules. 6 months the elections are not conducted. After 6 months, now what is the remaining term is barely about 6 months or 7 months is the time remaining. At this stage, the state government wants to say that we want to conduct the elections for the casual vacancy. One election, casual vacancy, general elections, cuts one day. But the state government cannot take a decision at the cost of the exchequer of the society, saying that for 6 months I am going to conduct the elections. This militates against the very scheme of the act.
Yes, you take notice when will you will have. Yes. You are taking notice to whom? Government advocate for. Yes. Copy is not served. State cooperative election authority, who is appearing? Kiran Kumar. One state government advocate is directed to take notice for respondent number 1. Kiran Kumar is directed to take notice for 2. Shimoga District Cooperative Center, you take hand summons.
I will take hands.
Yes. Assistant Register Cooperative Society will take 1 and 4 state government. 2 Kiran Kumar. 3 issue emergent notice. In addition, petitioner is permitted to take out hand summons to respondent number 3. When do you want? Including what? You file it in that office after serving. We'll see. No, without issuing the notice, how can that impleading application can be considered? Yes. Yes. So who has to answer the state? When do you want, Mr. Next week? Yes. Leave this matter next Friday. Next Friday.
Next Friday.
Yes.
Take it on Thursday for
Thursday. For this preliminary hearing. Yes. All this 2:30. Election is when? Nomination is agad. That cannot only contesting, only for voting. See, nomination allow madidre, then the problem is that they have to give that voting plus symbol has to be given. Nomination. No, rejection of nomination, file an election petition. If you want to vote, then I will permit. No. No, returning rejection. No, only for the contest voting, I will permit it. Tomorrow, yes. The voting third, yes. Tomorrow, yes. Adu tomorrow. Idu 2:30 na? Election voting. Yes, third. Yes, adu tomorrow. $22? Final hearing. No, who has heard? Where? Bharata, because of, see, this week I have that other court matters also. I three hearing matter tagondru kuda reach agidre ಏನು ಮಾಡ್ತಾರೆ? If there is any admission urgency, I can take it. I thought that next week. Tomorrow. Yes, tomorrow. Yes. Tomorrow? What is that matter? You challenge that election petition. How can I interfere, Mr.? That cannot be. Monday, not tomorrow, Monday. Once election has been held, this court has ceased, Mr. Younger agirli declaration admal mugitadu. Monday, yes, Monday.
ಎಲ್ಲ ತಗೊಂಡು ಅಲ್ಲಿ ಇಡ್ತಾರೆ. ಅದು ಇಲ್ಲಪ್ಪ. ಚಾನ್ಸ್ ಕೊಡ್ತಾರೆ ಮಾಡ್ತಾರೆ. ಏನ್ ರೇಟ್? ಅವನು ಬಂದಿಲ್ಲ ಅವನು ಸಾಕು ನಾಳೆ ನಾಡಿದ್ದು ಎಲ್ಲ ಹೇಳಿ ವಿದ್ಯಾರ್ಥಿ ಮುಗಿದು
What is that matter? What is that urgency? Yes. Tomorrow. Yes. 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 Where is that covered? What is it? True, Mr. All that annexure A and B only. Serial number into all Keshav Bhatt's matter.
Yes.
Madam. Same interim madam. Serial number 51 ಅಲ್ಲಿ annexures ಮಾತ್ರ ಬೇರೆ D and F. D and F. ಇದರಲ್ಲಿ ಮಾತ್ರ ಸೇಮ್ ಇದೆ ಸೇಮ್ interim madam. Yes. 50? No, all that Keshav Bhatt's matter. Yes. Yes, same. Yes. Back it correct. 51 also over. 54 is also over. 55 election is over. Become you are withdrawing. As a government advocate. Ad mugdogide election. You take notice for whom? Election authority 2, government advocate is directed to take notice for 1, 3, and 4. Kiran is directed to take notice for respondent number 2. The election to the society has been held on 5/9/2023. Hence, writ petition become infructuous, dismissed as infructuous. 58, yes. Election is done. Government advocate is directed to take notice for 1, 3, and 5. Kiran Kumar is forward to Election Commission Urala to issue emergent notice to respondent number 4. 4 notice. Learned the petitioner is directed to serve 2 sets of copies to government advocate and K. Kiran Kumar respectively. 5th respondent returning officer is directed to permit the petitioner to vote in the election to be held on. Permitted to vote in that election to be held on 9/9/2023 if they are members of the society. If they are duly members of the which society? Respondent number 4 society. Yes. Yes, handle it. Raju, yours also same. Same society. Same. Rank up. Government advocate is directed to take notice for respondent number 1, 3, and 4. Kiran Kumar is 2. Issue emergent notice to respondent number 5. fourth respondent returning officer is permitted to vote the petitioner in the election to be held on 9/9/2023 to the fifth respondent society if they are the members of fifth respondent society. Yes, if are duly members of.
Petitioner,
60 is become infructuous.
serial number 60,
60.
Rahul Reddy,
See, you said that, the members, 60, lose this matter tomorrow. It will become infructuous because today is the election. Lose this matter tomorrow. 61, we have granted interim order.
serial number 62, HP Rupesh,
62, where is that, Rudresh? Password. Yes, password. This 2:30 will have it any day. Ade. Alla parted athwa further hearing 2:30 post is different. Further hearing is different. Further hearing antidella. Yes, learned counsel for the parties has established that matter has been heard by Justice R. Devadas and posted for further hearing. Hence requested to post it before the same bench. Office is directed to post this matter before that Justice R. Devadas. When? Wednesday at 2:30. Yes. Interim order granted earlier is extended till next date of hearing.
number 18, Suvarna Partitioner, Bhagavacharyam.
Yes, when? 22? Now that, where is your affidavit? Here for condemnation of delay. Two sons, daughters, so and so, health and died due to sudden heart attack. And when he has died? 2021. This has been disposed of in 22. And then how can it? Then how you have proceeded that case before that HRRP when this, that would be the reason. Then from last 2 years under that shock. No, 4 months delay also you have not explained properly. You have given a reason, you file in a better affidavit. Yes. Learned counsel for the petitioner prays weeks time to file in a better affidavit. Yes. Correct reason could raise. Yes. 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 Execution actually bidi execution.
The petition was dismissed because there were no diagnostic
Yes.
they filed
No, any order of pass for execution of that this thing. Now case is posted, there is no warrant has been issued. You are residing there. You produce that any address proof on Monday. Monday. Release this matter on Monday. Yes. And also file in a better affidavit Monday.
Yes.
Yes.
Number 23, Jayaraj PS for Petitioner, Vijay Kumar.
Yes, Jayaraj. Yes. Hmm. One time. Yes, he wants time, Mr. Next week. Next week. Is this matter on next Thursday? Yes. At the request of counsel for the respondent.
Siddaramaiah.
Yes, Siddaramaiah. Now, on what ground do you have filed an application for rejection of claim? Suit for recovery of money. How much?
With urban boundary that given down here, different areas. If not,
ಆಯ್ತ್ರಿ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಪ್ಲೈಂಟ್ ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕಂತ ಎಲ್ಲೈತಿ ಯಾವ್ದ್ರಲ್ಲಿ $70? Yes.
To get a degree of constitutional performance has to prove that there is a subsisting agreement in this level. In the second instance, the legislative authority under the power of Congress. The full rules for the mandates that the public has to meet a constitution. Therefore, it has to produce the power of Congress in the right is presented again. And it is not in question of the state. The state has to in most cases it is. In the case of them, the agreement between the plaintiff and the state defendant has been filed, along with the right and the orders in the process. It is filed as well in the evidence in the process. It is not a question of the process. It may be a registered document. It should have read a legislative copy of the same. There is no such difference in the for not taking the legislative copy of the process. Others will instead of explaining most questioning about family is the plaintiff has simply stated its neighboring source non-compliance of the grade number 75 para number 21 may contain in view of the shortfall in the right amendments.
Which where?
in view of the short flow in the trade development, statutory clauses namely Article 11 42 foreign members participate in fighting in appendix C of the report which has statutory in nature. The report that others will get the report has finally concluded that the absence of any cause of action shown as clearly so cannot be considered either for specific purposes or for the money. Advance
No, that. Order. 7 rule 14. One. Register a document on which the claim shows suspects that the claim shows and upon the document of
Where innocent document is not in possession or power of the plaintiff, he shall where purpose state is used person or poverty.
now what is his claim?
Take to have received the money. And he is no explanation where they obtain documents.
No, that has he produced the check?
He has not produced it.
What he has produced then?
He has not produced any document.
During the defendant's bank loan certificate, the plaintiff is ever to yes, heard issue notice stay of further proceedings in YS number 117 of 2017 pending in the file of civil judge Davangere. Yes, civil judge and JMFC Davangere till next date of hearing. Why end delivery? What is that suit? Suit. Yes.
Mohammed Saeed,
Yes. Yes. Just give that brief facts of yes. Anyhow, you just give that. It's plaintiff appeal. Plaintiff appeal suit for yes.
And proceed with respect of land bearing 735/2 United of 1 acre 34.
35/2. Yes.
1 acre 34.
34 gunta.
When was the grandfather Nanjap has purchased this property and annexed it.
Grandfather.
For extent of 1 acre 34 acres.
When?
There are no transactions.
No, when he has purchased
31/1946.
13
1946.
1946. Yes.
Same copy is also produced.
Yes.
See the document under which my grandfather came into possession of the
Yes.
property.
Yes.
After the death of my grandfather, it was continued in the name of the legal case. There is a request made in my favor.
Yes.
That is also produced bill. That is also produced under the bill. I am entitled to entire suit law.
When that will, who has executed the will?
18/5/1980 during his lifetime.
18/5
1980.
1992 will in your favor
Yes.
by Nanjappa. When Nanjappa died?
But I have produced the death certificate also.
Yes.
It is on 17/12/97. Happened number 5.
Yes.
They have intended to put fair court in the unregistered will that cannot be backed upon. It is an intercept to be the legal case of Nanjappa in respect of which the defendants cannot carry the same. Nevertheless, if the administrator is not appointed under the bill, I think that's okay.
Yes.
That is central position. Now, the case of the contesting defendants who said to have derived title.
Hmm.
By Nanjappa, they claim that there is one state deed in the year 10/1/1984. 10/4/1984.
10/4.
10/4/1981, under which
Yes.
my grandfather Nanjappa,
Yes.
along with one other person,
Hmm.
is reduced at page number 93 months. Page number 93.
Yes.
My grandfather Nanjappa and along with one Manugurappa
Hmm.
have joined together and executed share deed to an extent of 3 acres 27 guntas
Yes.
in survey number 35 ward.
3 acres.
27 guntas. Manugurappa had 1 acre 34 guntas and my grandfather had 1 acre 34 guntas. That is their contention.
Yes.
In the body of the share deed blood,
Yes.
they claim that my grandfather
Yes.
has acquired this property and they registered share deed dated 9/1/1948.
Where is that?
Volume number 3200. Share deed dated 9/1/1948.
No, in which page you are saying?
Page number 93.
93. Hmm. Where is that?
Whereas the vendor's hearing
Hmm.
and the sole Khatedar and absolute ownership portion and enjoyment of the agriculture land within 3 acres 27 guntas,
Hmm.
assessed at so and so. Poonakunakara village, Bebu village, Bangalore, South Taluk, and holding the Kata so and so. Vendors having purchased 1 acre 32 guntas out of the said 35 ward called the registered sale deed number 3200, volume number 952, book 1, pages so and so.
Hmm.
According to the contesting defendant's blood,
Hmm.
my grandfather has derived right to this property, and this document.
Yes.
I am today producing one more document.
No, that's 21/1948.
1948.
Yes.
Whereas my state it is 10/1/1946, 31/1946.
Yes.
I already submitted.
Yes.
Today I am producing this document which also produced the declared.
Yes.
Now the present borrowers who claim to hold possession and taking,
Yes.
they also contend, page number 14. Can you take page number 14 of the document which I have produced?
Yes.
Because earlier property very surrender 35 or 2.
Yes.
Every 2 acres belong to Mr. Nanjappa, who acquired the same by virtue of the sale deed dated 9/1/1948. Kindly mark.
No, where you are reading?
Page number 14, today's document.
14. Which paragraph?
Paragraph number 1.
Paragraph number 1.
Whereas earlier property very not mentioned. Bearing survey number 35 or 2, measuring 2 acres belong to Mr. Nanjappa, who acquired the same by virtue of the sale deed dated 9/1/1948, registered in the office of the Subdivision of Bangalore, with document number 3200, book 1, volume 952 at page 51.
What is this?
This is the document under which this whole property was purchased according to the defendants.
Andre iದೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದು?
Produce ಮಾಡಿದ್ದೀನಿ.
ಅಂದ್ರೆ ಇದೇನಿದು ಅನೆಕ್ಷರ್ ಪೇಜ್ 14 ಅಲ್ಲಿ ಇರೋದು ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಶೀಟ್ ಅಂತ?
Kindly take document produce now.
ಅದರಲ್ಲೇ ರೀ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದು? ಸೇಲ್ ಡೀಡ್
Sale deed.
ಯಾರಿಗೆ ಮಾಡ್ಕೊಟ್ಟಿದ್ದು?
By vendors, the defendants vendors vendor.
ಡಿಫೆಂಡೆಂಟ್ಸ್
Vendors vendor.
ಯಾರವರು?
Is Fatima, Afroz, Shamsuddin and others have sold 8/9 defendants have 8/9 sold it to the other defendants.
ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್
8/9.
ಅಲ್ರಿ ನಿಮ್ಮ ಗ್ರ್ಯಾಂಡ್ ಫಾದರು ಯಾರಿಗೆ ಫಸ್ಟ್ ಸೇಲ್ ಮಾಡಿದ್ರು?
My grandfather, according to them, has sold it to 10/1/1948.
10/4/1941 10/4/1981 ಅಂತ ಹೇಳಿದ್ರಲ್ಲ,
10/4/1981.
ಯಾರಿಗೆ ಕೊಟ್ರು ಅದು?
He has sold it to Amir Khan, Shamsuddin.
ಅವ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ವಾ ಅವರು? ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೆಸರು? ಅಲ್ಲ, ದೇ ಹ್ಯಾವ್ ಸೋಲ್ಡ್ ಇನ್ ಟು ದ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ ಹೇಳಿ. ರೆಫರ್ ಟು ದ ಡಿಫೆಂಡೆಂಟ್.
The legal case of that starts from defendants 3 to 8.
ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್
3 to 10.
ಇದರಲ್ಲಿ ಇಲ್ವಾ? ಕ್ಲೈಂಟ್ ಎಲ್ಲಿದೆ?
Appeal memo itself.
ಕ್ಲೈಂಟ್ ಎಲ್ಲಿದೆ? ಅಪೀಲ್
Plain
Page 159. Our Yari sold mother first to 10/4/1981. They are sold to
The predecessor in date of defendant state.
defendant
3 to 10.
3 to 10.
10/4/1981.
Yes, 3 to 10.
They return forward to the other defendants. One now claiming to be in possession.
ಯಾವತ್ತು ಅವ್ರಿಗೆ ಮಾಡಿದ್ರು ಅವರು 3 to 10 3 to 10 has sold. This is that sale date. What is the date?
Date is 17th December 2015.
17 December
2015.
2015. 3 to 10 has sold in favor of
The other contesting defendants.
Yarna. Yes, really.
Correct. Equal to 29.
12 to 29. Yes.
This document have to do.
ಅದರಲ್ಲೂ ಅದನ್ನೇ ಹೇಳಿದ್ದಾರೆ ಅಂತ.
9/148 ಇಂದ ನಮ್ಮ ನಂಜಪ್ಪನ ಹೋಗಿದ್ದು ಅಂತ ಹೇಳಿ.
Yes.
I have reviewed the sale date of year 9/1/1948.
9/1/1948.
Fairly good to take number. I produced it 248, page number 248. Paper.
Yes. Yes. What is this?
I'm sorry, this is not it. Page number 108.
Right.
Same document, document number 3200, sale date 9/1/1948. Volume number is also same. Kindly go to the schedule at page 109.
Yes.
ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಬೇಗೂರು ಹೋಬಳಿ ಪೂರ್ವಪನಾಗ್ರಹಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 54ನೇ ನಂಬರ್ 2 ಎಕರೆ ಆಕಾರ 2 ರೂಪಾಯಿ 8 ಗುಂಟೆಗೆ ಚೆಕ್ ಬಂದಿದೆ. Different property. The bond is also different.
No, this is also purchased by your grandfather.
So
This is survey number
This is survey number 54.
54.
This is not survey number 35/50.
Yes.
So they are laying claim in respect of the portion of survey number 35/2, that is the school property, on the basis of the sale deed.
But sale deed ಅಲ್ಲಿ boundary ಯಾಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಯಾವ್ದ್ರಲ್ಲಿ?
ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದ್ರಲ್ಲಿ.
ಅವ್ರು purchase ಮಾಡಿರೋದು 35/2.
1981 2015 ಅಲ್ಲಿ
35/2 ಕೊಟ್ಟಿದ್ದಾರೆ. 35/2 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದು ಬೇರೆ ಕಥೆ ಇದೆ, ಹೇಳ್ತೀನಿ ನಾನು. How fraud is being made.
Yes.
So according to their own case, forget about my case.
Yes.
According to their case only,
Yes.
the property which my grandfather purchased in the year 1948,
Yes.
which is in respect of survey number 54,
Yes.
it is the property which they have purchased, and it is the property in respect of which they are laying claim as the scheduled property.
Yes.
My respectful submission is, it is not the plaintiff's case. Not taking into consideration the full particularization and intention. These issues relating to the title and possession have to be established upon time. Right? Here is a case where the defendants lay their claim in respect of a sale deed of the year 1948, in respect of altogether different survey number, different properties, different extent. To lay claim in respect of the suit property,
Yes.
where there are no transactions from 31/1946 up till date.
Yes.
Have reduced the internal certificate. What happened to this man? And I have filed the suit and appeal before the Supreme Court. I have updated incomprehensible. There are only 3 entries.
Yes.
Subsequently, there are 4 entries of subscription. I have managed everything. A certified copy is created. I have applied for the certified copy online. Online provision is made now.
Yes.
Yesterday I applied, today I have applicated. And this property. My respectful submission is, though the defendant's case fraud having purchased this food property on 9/1/1948 in respect of survey number 54.
Yes.
To an extent of 2 acres.
Yes.
They cannot lay claim in respect of survey number 35/2, which is altogether different property.
Yes.
Their request was not to get go to the detailed submissions which are placed on record, written submissions are placed on record for the trial court.
Yes.
In 267.
Yes. Then what are the documents which shows that you are in the possession in 35/2?
35/2 not. Revenue entries still 35/2 in the name of the purchaser. By the predecessor in trade law, the contesting independent.
Not that vendor of Nanjappa. Nanjappa, it shows that name of respondent number 3 to 10.
Yes, yes. I mean, now they have got subsequent entries based on.
Now that after that 12 to 29 has get it entered. Your name has not entered anywhere.
The revenue entries not. Revenue entries are always reverted.
Yes.
Yes, for if it were to be a suit for injunction simplicity,
Yes.
I agree that there is a legal presumption. In a case where the parties are pointing out a serious question of law and fact, substantial question of right to be addressed.
Yes.
The entries in the revenue records are always rebuttable. If I am able to establish on Fulton's trial that the entries are not on the basis of the sale deed of the year 31/19.
You have not challenged that.
I have challenged it.
Before that, the
No, I
company.
have challenged it. Thereafter, I filed a suit for injunction. There they have produced the sale deed. I withdrew the suit, injunction suit actions. I noticed that such a sale deed is set up.
Yes.
I withdrew that suit with the liberty to file a fresh suit. And I filed a comprehensive suit for declaration of injunction. Kindly see the interim order passed in the earlier occasion. Now, the question is now, earlier occasion, the interim order is passed. And regard to the photograph which I produced before the trial court.
Yes.
The trial court was pleased to see that the rights of the parties should be defeated. A serious question of law and facts are to be addressed in the matter of trial. Don't put up construction. In their case that they have got a valid sanction plan also now. A foreign developer has come into picture. Now they are contemplating a huge commercial complex.
Yes.
My respective submission is written. Prima facie, on the basis of revenue documents, the honorable court prima facie may hold that they may be found to be in possession. But in a case where issues are to be addressed in a suit for declaration and injunction,
yes.
The property should be preserved as it is till the matter goes to court. That is my responsibility.
Yes.
If the defendant can see the balance of convenience and
Yes.
balance of convenience, if the defendants are to be permitted to put up use construction, commercial construction lot.
Yes.
If I succeed in it tomorrow,
Yes.
what will be my fate? Third party interest will be created. New commercial complex they will put up. They said to have purchased more than 1 acre 34 guntlas. It will be very difficult to demarcate the structures which are come up in respect of my property. These are the issues which will creep up
Yes.
if they are permitted to put up construction.
Yes.
They use the shadow casted upon the rights of the defendant.
Yes.
Another aspect of the matter.
Yes.
I will go by their own written submissions which they have placed on the card. Not my case. It's their case also. In the written submissions filed on 29/5/2023 before the Supreme Court.
This court.
This court.
29?
Memo 29/5/2023.
Yes.
Written submissions.
Yes.
Paper book ಹಾಕಿದ್ದಾರೆ. He said, ನನ್ನ case ಮಾಡ್ಕೋಬೇಡ. Left ಅಲ್ಲಿ ಇರೋದು this is how I derived it.
Wait. 29/5.
29/5. Memo. The undersigned counsel humbly presents the flow chart of the title.
Application under 49.
ಒಟ್ಟಿಗೆ ಹಾಕಿರೋದು.
Amended appeal memo.
ಆದ್ಮೇಲೆ ಕಾಪಿ ಆಫ್ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್.
Yes. Yes.
Same deed recorded by defendants in their title deed.
Yes.
Defendant document number 3200 dated 9/1/1948. Just to read over. Extent of 2 acres in surrey number 35 ward. This is totally correct. Surrey number 35 ward to my grandfather had only the 34 meters.
Yes.
And the document number 9/1/1948 refers to surrey number 54.
Yes.
Not the surrey number 35 ward. It is not my contention, it is their contention.
Yes.
In favor of Nanjappa from the vendor, CH-12 copy of document number 4. The document also they have reviewed. 9/1/1948 document. Some property sold to respond for age husband and father from 9 and 10 along with his succeeding along with brother vendor Yandurappa and White Shed dated 10/4/1981. So what was sold in 10/4/1981? Well, according to them, it is the property which they have purchased with the same date dated 9/1/19.
Yes.
There is absolutely no doubt, ambiguity at all. If they have purchased this property, true property at 9/1/1948, which is referable to altogether different property. 54. And the two extent is different, boundaries are different. Is it not a matter to be addressed in the full statement? Yes. I am prepared to give an undertaking to some court. Trial shall be completed within 6 months. Day-to-day trial I am prepared to take. Let them not put up construction and create third party. That is the interim order passed by Islam court, and the matter was heard by both the sides.
Yes.
Hearing both the sides, the interim order is passed.
Yes. Where is that? Wait, Mr. He has not completed.
What is it?
Right. Yes. Where is that?
Interim order on the date of completion. Sorry. I will not put up construction. It would page number 258.
258 of?
258 of the paper.
Yes.
Dependent certificate.
Yes.
Really, certificate what my grandfather has purchased it and paid it up here 1946. Only the 34 quotas.
258.
258. And the thing you will watch it, you please to see
Yes.
the encumbrance certificate which they have produced.
Yes.
But page number 262. This is very strange.
Yes.
One more entry has come.
Yes.
4 entries.
Yes.
Nanjappa sold it to Dodavaya.
Yes.
Is not there contained in the written statement that after the sale deed of dated 2/9/1946, my grandfather again sold it to Dodavaya. It is not that case in the written statement also.
Yes.
How did they get the entry?
Yes.
So I have applied for online encumbrance certificate for registrar.
Yes.
So that will throw light on the case, and I can summon that document at 13/10.
Yes.
For the trial court in the matter.
Yes.
So this is the case where
Yes.
I am relying upon some judgment. Of course. First judgment was made to read it. Para 9 and 10.
Page number?
Page number 9.
Yes.
Generally, however, the interlocutory remedy may be of grant
Which
order.
is that judgment? That is the first judgment.
First judgment.
Yes, 1999.
Paper 9 and 10.
Page number 9, no, that is that 1999 judgment. Start from page 3.
Yes, sir.
Yes. 1999.
Para 9.
No, first we'll note down that judgment. 1999, 7.
SEC.
1. Page 1. Yes.
When you go to para number 9.
Yes.
Generally, however, interlocutory remedy may bear the grant of an order of injunction is intended to preserve or maintain the status quo, the rights of the parties, and to protect the plaintiff being the initiator of the action against the intrusion of his rights, and for which there is no appropriate compensation being quantified in terms of damages. The basic principle of the grant of an order of injunction to assess the right and need of the plaintiff as against that of the defendant, that is the duty incumbent upon the law courts to determine as to where the balance lies.
Yes.
So I have made up a prima facie case so that
Yes.
on the premise of purchasing the property by the registered document of year 1954,
Yes.
which is altogether different property. They are laying claim in respect of real property which was purchased by grandfather in 1946. In the context of which I have made, if not 100% prima facie case, I do concede for
Yes.
a moment. Having regard to the fact that there are revenue issues there,
Yes.
which is always rebuttable. Nevertheless, there is I have made a prima facie case. It is a travel case on in the matter on Lotus Play.
Yes.
With such time, the status quo is to be maintained. That is the basic principle.
Yes.
Another remaining feature in the matter of grant of interlocutory injunction is that in the event of grant of injunction, we not be party dependent, where the date enterprise has commenced, and in that event, the consideration will be somewhere different where the defendant is yet to commence in the defense. Now I have to do the photographs.
Yes.
Because we have started digging the ground, laying foundation. Immediately after, there are no latches. Initially, I was informed the trial court in the suit for injunction simpliciter.
Yes.
I found that they have set up some document. I will do this suit and paid a comprehensive suit. The trial court, having regard to the photographs produced before, the trial court has passed an order not to put up construction. That was challenged in the earlier occasion.
Yes.
And so many other documents were produced. It was remanded back. Again, I suffered an order. Now I am before this order. I am before a court of equity.
Yes.
Some foreign enterprises have taken over the issue now. Huge commercial complex will come up in 3 acres and agriculture. Where this poor man will start litigating after the huge construction is come up. How do the construction will be demarcated? In which place the
Yes.
construction is made? So these serious questions will creep up if the defendant is permitted to put up. Your judgment is not. Second 89 part 5 Supreme Court
Yes.
is 24.
Yes.
If they go to para number 51 and 50.
Para number?
51 and 50.
Yes.
Stack wrote that we have to consider the applicability of By P. Choudhury versus Sikar of P. Sutantra. In that case, because notice that if the respondents were allowed to set up construction by the use of FSI of the whole land, including land involved in dispute, the situation would become irreversible by the time the dispute is decided and preclude fair and just issue of the matter. If on the contrary, injunction is granted, as great for the respondents are not likely to be typically because they were in version of the substantial land on which they could. It have been easy for this court to avoid granting an injunction. The builder and the group had come forward with some equitable offer to step what the injunction would be. The plaintiffs were actually deserted by the others in the local group and they are vehemently opposed by the deceased father that way for the commission. So what is and they come up with some offer. You have to have been domestic player, cooperate with us. Suppose it
It therefore comes to conclusion that I am not trying to, there ends the matter.
Yes.
If they are permitted to put up, initially, though the prayer is for not to interfere with the plaintiff, Islam court can hold the relief and say that both the parties maintain status, not to construct. That would be more equal to respectfully submit that would be not to pass with the hands of us.
Yes. You are appearing for 2 to 10. 2 to 10 is that first purchaser. Other. That is defendant number 3 to 10. Yes. $258. No, you first reply from that beginning what he said. Sale date, survey number is different. All that you first reply. Then you come to the 93. That you have purchased. Yes, purchased. Yes.
And this sale is calculation of the sale of the person.
Yes.
One is part.
Yes.
The total consolidated date is 387.
Yes. Yes. Yes.
But I was holding half the line. The digital secretary number 320. And second of the vendors having inherited the extent of 1 acre 24 kuntal corresponding to RM.
Yes.
Is the person that is succeeded to the property after the demise of his father, William, who has acquired the property under the register. But 638
Yes.
Now, from the scale of this sale deed, very clear that this particular sale deed is required to the person. You are calling on same survey. But my learned friend is always going to be somewhere on the boundaries. But the boundaries of this river path is the same, and this is the same property which my learned friend is claiming. It is what you can find this aspect of page number 250. Here the type copy here, page number 260. Is the respective same property which my learned friend is claiming again.
No, that first come to that the sale deed scheduled in that page 93. 93.
Because the consolidated sale deed of the property.
Yes.
For that reason, there is some variation.
Yes, sir.
To look into the sale, you have to see the earlier sale deed.
No, scheduled they have mentioned 35/1 and 2.
Yes, 35/2. And both the property, they were holding 35/2.
Yes.
35/2.
Yes.
Village. And the foundation was given. But after the sale deed,
yes.
From 1981, all the documents were transferred to the name and according to them, the deals are built by 1982 and the depot was there in 1987. During this entire period, he never made any effort. Doing his lifetime also.
to contest against the revenue entity. Now, this will be why I am taking it is very important. Also, ask the EC with my learned friend is in trial.
Yes,
258. The right copy is the first copy. 8 the right. Number 35 by 2, 1 acre 34 Punta. Sindaramaya, the purchase the school this property, Punjab. City number 854. And the same document, if my landed friend is claiming, this is 854.
no, 260. You want what you want to show in the 260 page 260?
260 is the type document. This is AC.
Type copy.
This is AC of the same property my landed friend is claiming.
Yes.
That is the first increase history of the sale.
Yes.
And there is another two entries are there also.
Kottavaru Sitharama Ramaya.
Ramaya and Punjab.
That before snake cut. ಆಮೇಲೆ
This is the 1946 sale.
1954 ಅಲ್ಲಿ ಏನಿದು?
That's the next sale. And the last sale got you.
ಅಲ್ಲಲ್ಲ ಇದ್ಯಾರು ದೊಡ್ಡ ಬೈ ಅಣ್ಣ ಪಾಪಯ್ಯ?
All property there. In between that one transaction must happen. Where the Najappa sold it to the particular money.
No. I will come to that. Easily Sitaramaya Nanjappa ಕೊಟ್ರು. 1954 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಕಾಲಮ್ ಅಲ್ಲಿ ಅದು ಇದ್ಯಾವ್ದು ಟ್ರಾನ್ಸಾಕ್ಷನ್? ಅಲ್ರಿ ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದು ಏನಿದು ಪಾಪಯ್ಯ ಯಾರು? ಅಲ್ರಿ ಇದು ಯಾರ್ರಿ ಇದು ದೊಡ್ಡ ಬೈ ಅಣ್ಣ ಪಾಪ? ಅಲ್ಲಲ್ಲ ಇವ್ರು ಯಾರು ಇವ್ರು ಅಂತ ಇಲ್ಲೊಂದು ಇನ್ ಬಿಟ್ವೀನ್ ದೇರ್ ಇಸ್ ಅ ಸೇಲ್. ಡಾಕ್ಯುಮೆಂಟ್ ಇರ್ಲಿ, ಇದು ದೊಡ್ಡ ಬೈಯಣ್ಣ ಪಾಪಯ್ಯಗೆ ಸೇಲ್ ಮಾಡಿದ್ರ? ಯಾರು ಈ ದೊಡ್ಡ ಬೈಯಣ್ಣ? ನಂಜಪ್ಪ. ವೆನ್ he has purchased?
1947.
262. ನಂಜಪ್ಪ ದೊಡ್ಡ ಬೈಯಪ್ಪ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ
the same property, the two brands, it was merged to this particular semi-city.
No, see, first to Sitaramaya Nanjappa. Nanjappa is not your no, that is the your grandfather.
Yes, that is my grandfather.
Nanjappa has sold to that Dodda Ramaya. Dodda Papaya.
Papaya sold to Muniyappa. Papaya sold to Muniyappa. Muniyappa is none other than father of Vendruppa.
Muniyappa is
the father of Vendruppa.
another vendor.
Nanjappa has executed the sale deed, 1946 sale deed. Where is the question of executing 10/4/1988?
But now my landed friend is saying, in between transaction which I am showing the Nanjappa program, I have considered when I if such is the case, what should be my landed friend also there? If we take the sale deed of Telecast, so it's only a sale deed represented.
Yes.
The sale deed represented in my document. Right? There's a first column.
Memo, what memo?
There is a memo which I have followed. The memo which I given in 29/5/2000.
This one, yes.
Yes, sir. The first column. This is the first sale deed my landed friend is referring and claiming.
Yes.
1480. 1940. This is the Nanjappa sold to Sitaramaya. Next is sale deed is 6/1/1927.
Yes.
Document number 3/8.
Yes.
This is Nanjappa sold to the buyer. Then same person Budabanappa has sold to Sitaramaya. My landed friend is showing this particular sale deed RF2. I have fabricated or increased all the time. Because a tiny take RF2 page number 20.
No, that your case is that
The
Nanjappa has sold only half portion that to that.
These are two property was there in place in survey number 32. One property was sold by me by Nanjappa directly. Another property is my landlord friend is claiming. Nanjappa has sold it to Dudapayappa has sold it to Sitaramaya. Sitaramaya has sold it to Muniappa, and Muniappa's son has sold it to me. So the both of our property are purchased it. That is the case. Am I
Yes.
So that is I also kindly appreciate. Now my landlord was reading the affidavit, and he's saying this affidavit rectification I had rectified and all those things.
Yes.
Kindly take the affidavit is number.
222.
221. But this is not my affidavit.
Yes.
Is it the affidavit which you have produced?
Wait. Yes.
It's not my affidavit. My vendor has given the affidavit.
Yes.
And what Nanjappa has said that this property is here purchased.
Yes.
The sale which is received from Chikatayama. In that properties, there is a discrepancy of mentioning of survey number.
Yes.
By mistake it was mentioned, and it is happened in 1947.
Yes.
1947.
Yes.
Then in this particular survey, 1947, column number 2 also,
Yes.
there is a discrepancy of survey number.
Yes.
The land is described as survey number 54 of the, there is up to date survey number 35/2.
Yes.
Okay. I have transferred the sold the said land 1 acre Kunda in a to one Amir Khan and son of Adar Khan and Shalishu. So this affidavit is executed by Nanjappa in respect of some discrepancy in the property which is whole matter. Assume that there is a discrepancy.
Yes.
Assume that there is a discrepancy. There is a two property. One property is my landlord friend is claiming that his property he has purchased it. The same property is sold to another person, then it is being sold to Muniappa and Muniappa sold to. So it is evident from the document. My landlord friend is pointing out that this document I have applicated, I have applicated. But you can find the answer. In this lordship will read the document number RF page number 21. This is the sale date. 40.
Yes. Yes.
Date number. Date 20 of 19.
Yes.
I copy that. The translated copy is there.
Yes.
20. That I copy. See schedule number. And there is a reference version, page number 25.
Yes.
लिखी के लिए कंडे उसकी जब मार्का लगे रहा है और लोग नंजम्पा तारीख में सोएंसो अभी मेरा तो आगे बेंगलुरु का सब की ऑफिस एक नंबर आगे आगे बेडने आइटम
ಆಯ್ತು ಬಿಡಪ್ಪ ಆಯ್ತು. Yes.
This particular number said.
Yes.
So that the contention of my landlord and I have interpreted this particular document.
Yes.
It is not correct because the reference was there in the sale deed which was given to Petitioner.
Yes.
So my other condition is not it. And why? How my landlord in one of the sale deed of subsequent person.
Yes.
They just found there is some discrepancy. So they realize some option. There's some opportunity. For that reason, they have started everything. The property Manjapal is a holding in one bus sale.
Yes.
That property was sold and it came to us.
No, that is not necessary. I am not deciding any title of the, it is not a declaration, it's an injunction.
But
Yes.
the thing now comes the deal. They are one condition the 97, right? They had filed a suit somewhere around 1981 till 2016. Assume that 2016 they have filed a suit.
Yes.
Till that they have never made any contention regarding it. There was no issue of disputes of anything, and they don't have any simple original document, not even one single original document they have produced.
Yes.
And all the documents, original documents are with us in respect of both the properties.
Yes.
And all the technical documents are with us.
Okay. Where is that license you have put?
Also get produced. That also was contested very vehemently. I have produced all the licenses. I satisfied it. Court has directed it to produce license. The trial could also be produced. This could also be produced.
Yes.
Even we have converted the land.
Where is?
Even the land for this national highway that in 1984, 500
No, that you have taken permission for the agriculture land has been converted to non. Yes.
Immediately we have complied.
Now you come to that finding of the trial court.
Trial court has considered each and every document, and after that we are finding that the vendor is not in.
Quite before the getting part of the property was not sold. Yes. No, that yes, yes, yes. That he has read. Yes, yes. Yes. Certificate filed by the court for beginning of sound, so verifying the incompetent certificate.
How and when you pay for
Now you read para 43.
advocate for There is no reference to the outside component. In between transition, but the recent government between the both of them for this.
Yes, I have gone through that. Yes, yes. What is your next argument?
So my humble submission.
Yes.
They have themselves as fabricated. And based on the fabricated, they are claiming that the property is 1946.
Yes.
They are not sold it to others.
Yes.
But from the revenue, the documents.
What is that your application? What is that IA you have filed?
IA number 2 also I have filed it for the notification of the order.
Yes.
Very reason was that.
No, IA 3.
IA 3 for the dismissal on the ground of the institution for. So that already I filed a jurisdiction. I have challenged the
Jurisdiction of?
Why?
Why? No, why it is not maintained?
My humble submission. Because they had said that. the claim.
Mm.
So in that event, their appeal will lie only in the trial. But they, in the first appeal, they had saw, in the first appeal, they had put 460 lakh per acre is a government guidance.
Hmm.
Now in this particular appeal, they said 60 lakh.
Hmm.
And they have not paid the court to properly do the trial.
No, that you can agitate. No, why this is not maintainable before single
The
judge?
reason for that was.
Yes. No,
As per section
no,
48,
that we have earlier clarified. It is valid more than 4 crores. Therefore, he can file before this court. Now, you said it is not, if it is not.
the same value has to be considered apparently. That was my contention.
No, that you said it is not maintainable before that single judge.
Not before. Before this court, it is not maintained. Because my contention was that as section 49 of the court fee act, the value which was required in a first instance, the same value has to be considered appellate. They cannot change the value
Yes.
for the sake of.
That earlier on, now that, no, last occasion you said that, no, you said it is more than 15 lakhs, therefore it is not maintainable before this court. Single judge.
So 60 lakh they had mentioned. They had mentioned 60 lakh.
Where is that? If it is more than 15 lakhs, it has to go before the division bench. 15 lakhs, it has to go before the division bench. Where is that, Mr.? Show me that. Where is that law? Where is that? See, there are only a 14 section in that High Court Act. Nobody is ready to read. See, there is no limitation for that application filed under Order 43, Rule 1R. All that appeal comes to the single judge. You see that? Yes.
My contention was this before the district.
Yes.
Because of the first instance.
Yes.
I had pointed out 60 lakh just getting a subsequent.
Yes. Yes.
That is only my submission.
Yes. What is your?
For the sake of, I just the title they are claiming.
Yes.
The itself clearly shows from the old document that property itself is sold to somebody else, some other person, and same in similar way after the transaction, the other supplier sold it to me, and it is matched with the total extent of the and I am the writer, and from 1981, without any controversy, I am the writer.
Yes. Yes, Mr. Your defendant number? 12 to 29. From them, you have purchased.
There are subsequent purchases. He has no interest.
Yes. Yes. Paragraph number 95. No, he has sold the entire extent to you. You have sold the entire extent, Mr. He is left. Yes. Yes. Page 95. Yes.
The builder here is negotiated with the purchasers for the sale of the property, which is classified by right out of survey number 35.
Yes.
So the intent of Punjab
Yes. Yes.
This statement is also available.
Yes.
The first paragraph of the page for 95. The intent of Punjab may have to be gathered from this particular document only, not beyond that.
Yes.
The first paragraph in page number 95 also refers to the survey number 35/2.
Yes. Yes.
Fifth says the entire extent of 327 hectares.
Yes.
Out of survey number 35/2.
Yes.
This concerns to operates demonstrate at page number 103. The boundaries of survey number 35 is what is mentioned in the boundaries of this particular safety. Yes. Yes. We mentioned in page 103, the particular safety has not been disputed.
Yes.
By the is also saying that this is not about survey number 35.
Yes.
This is survey number.
Yes.
Because Anjappa was a program of two survey numbers.
Yes.
One was 35/2.
Yes,
The
I
other
understood.
was 74.
Yes, I understood that. Yes.
So this particular boundaries are concerned.
Yes.
This is the boundaries of.
Yes.
This is one of the segregation of monarchy.
Yes.
It's Gopal Reddy has signed. This Gopal Reddy is none other than the father of the present plaintiff.
Yes. Yes.
I appreciate this particular safety was secret on in the 1981.
Yes. What is that? Hmm. Yes. There is no dispute. Yes. 1990. Yes. Yes. Yes.
Had intention of selling 35/2. The possession was with not Anjappa because in 1980 to 81 itself, the regular records were transferred in the name of the president.
Yes.
If Anjappa had 35/2, under section 20 of specific relief act, I think I can be appreciated.
Yes. Yes.
And as a reasonable explanation that such instrument, if there is outstanding, then causing serious injury, then sue the injury and and the court may so and order it to be delivered to the cash.
Yes.
So Anjappa was alive for almost 16 years.
Yes.
So the date of execution of the.
Oh, you are saying that he has not filed any suit for cancellation?
Any suit at all.
Yes.
Because they were taken up to.
Yes.
1997.
Yes.
The entire case of the revolves around the film.
Yes.
As not the day of like 2016 was initiated. After the injunction.
17 to 97. Yes. Yes. No, that earlier suit for injunction. Is there any pleading that there is a will? No. Earlier suit they have filed for injunction. Is there any pleading that there is a will in their favor? First time it's also yes. Yes, yes, true. Yes, yes. You are saying that pre-2016.
Were initiated with the based on the bill. So that goes to show the revenue increase was standing in the name of 8 years of beneficiaries in title was never called in proceeding on answer. The proceedings in which in the year 2016 that can be dismissed. To my knowledge, no appeal has been preferred by the review.
Regarding what? That is all subject to result of the suit. Whatever may be that revenue entries. See, advantage for you is that to claim for any injunction. Revenue entries, presumption is only for the claim for an injunction. For a title and all, if you succeed, everything will go. Yes. Yes.
Second, right. I mean, the submission is that they are not going to make one piece against before we solve it. But if we pass a second submission,
Yes.
so kindly appreciate it, each other to take before the order.
Yes.
Right, copy as to 64 is lower. 64.
Yes.
For registration, the name of the purchase of this land, they have to be majorly one of the essential ingredient and the registration will be.
Yes.
Here, appreciate equation 64.
Yes.
This stand paper does not even mention in whose name of the stand paper was sold.
No, I am not deciding validity of the will and all. That cannot be.
Right.
Yes.
But I have to cover.
Yes.
Submission, what is that?
Yes.
Technically, what the virtual documents as well as submitting the 35 articles concerned.
No, that 35/2, he has purchased 3 acres total. 3 acres, 27 guntas, 24 guntas. Entire 3 acres, 24 guntas you have purchased. He has left with nothing.
Yes, then.
No, see, he has sold the entire extent to you.
Some portion, some
No.
another some people is not.
No, see, I'm asking, in your sale deed, entire 3 acres, 24 guntas you have purchased. Yes, yes. Yes. No, see, first, his client has purchased that property. From him, you have purchased. What is the extent I am asking?
It is 1 acre, 2.05 meters. And
No, on 7/12/2025, you have purchased only
1 acre, 2.05 meters.
you have purchased 2 acres, 2 acres, 5 guntas. Two acres, 10 guntas. Remaining 14 guntas is with him. Yes. Then to what is that you are doing now? Section. What you are doing in that property? Remaining. Yes, you are. Yes. One. Yes. Yes. 181. Document number 9. Yes.
Some portion of also require the extended service parties and bonuses to be and should be since 20 of May. Identification came on 26 as by motivation.
Yes. Yes.
Yes.
Yes.
The entire land of which is 24 Gupta.
Yes.
Is converted for market.
Yes.
Various sites are various dimensions. Those countries are not solved at all.
Yes.
Estimated about each place and time to return, even that there are various functions. In their action, saying after the definitely between the kind of work functions also in that solution way, they really appreciate if they started the application. The application phase would do even the kind of
Yes.
is there for intention cost, and these also.
81.
Yes. He has not been very right to see case at all. Because for getting a numbers concept and he almost done the property by the construction. The other thing is natural and definitely not the act of survey and also the name and because the rest.
Wait, let him come.
Before and after the construction of the land, where it was found that each respondent for possession of the property and based on that, I will be covered. I think considering the land we have. We cannot have that also. Just simply to point to the date and the.
Wait, let him finish that.
He cannot get better taken than my relatives.
Why? Now he is in the possession.
No.
No, he is claiming that now he is the owner. He has nothing to do with that. Whatever the sold.
He having purchased from my relatives, right? He would step into the shoes of my relatives, right? He will not get any better taken than his vendor.
That is true. But he has to defend because he has purchased major. Actually, he don't have what the way he has raising and making. I thought that entire he is building that what is that some mall or complex. He has left with
Compensation. Acquisition in respect of the other portion which they have purchased from Manguru, not from our property.
Yes.
Those things should have to be established in the trial. We cannot back upon the proceedings which are initiated for the purpose of perquisition that we have received the order.
Yes.
My specific contention is it is not the land which is acquired from my property. It is
yes.
number 27, 3 acres, 27 acres. My property is only 1 acre 34 acres.
Yes.
And it is not made out with defendants. It is in respect of my property, the land was acquired. It is not their case in written statement.
Yes.
My relevant have read over the affidavit. Why Nanjappa kept quiet? From the year from 10.4.1981 till year 2016, why he kept quiet? The answer is found at page number 222. They themselves obtained an affidavit from Nanjappa to say that it is not the property which is sold in respect of 35/2. It is surrender 54 in 1948 document.
Really?
Okay, 252. Page number 252.
No, it is not 54. It is 135. Not reverse.
Sorry, the guy look page number 252. Sorry. Written statement also.
222. What is that?
Affidavit. He said Chikkapayama way of Umaya, sale deed number 3200. 9148, I sold the same land to me and held Khata numbers, but inadvertently the land is declared in the sale deed as surrender 54 of the village, whereas it ought to have been surrender 35. 48 ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ 54 ಅಂತ ಇರಬಾರ್ದಾಗಿತ್ತು 35/4 ಇರಬೇಕಾಗಿತ್ತು 54 ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ 1948 ಡಾಕ್ಯುಮೆಂಟ್ 7/54
ಆಯ್ತ್ರಿ ಸರ್ವೆ ನಂಬರ್ 54 ಅವರೇ ಸರ್ವೆ ನಂಬರ್ 54 ಅಲ್ಲ 35 ಅಂತ ಹೇಳ್ಕೊಂಡು ಮತ್ತೆ ಯಾಕೆ ಸುಮ್ಮನೆ ಕೂತ್ಕೊಂಡಿದ್ರು ಅಂತ ನಾನು ವಿಲ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ನಾನು ಪ್ರಾಪರ್ಟಿ ಬರ್ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಮಾಡಬಾರ್ದು ಅಂತ ಅವ್ರ ಕೇಸ್. ಅವ್ರು ಬಿಟ್ಬಿಡಿ, ನಿಮ್ ತಾತಂದು ನಿಮ್ಮ ಯಾರೋ ಅಜ್ಜಂದು ಅಜ್ಜ ಹೇಳ್ತಾ ಇರೋದು ನಾನ್ ಕೊಟ್ಟಿರೋದು 54 ಅಲ್ಲ 35 ಅಂತ.
ನಾನು ಹೇಳೋದು ನಾನು 35 ಅಲ್ಲ 54 222 clearly says that it is not the property which has sold in 755/2, it is 54. In the
Where
written
is that?
statement also.
Now we have read.
Yes.
What is that written there?
Yes. He has sold the same land to me and the Khatam
Survey number 54 where it ought to have been survey number 35/2 ಅಂದ್ರೆ ಏನಂತ?
document ಇದೆಯಲ್ಲ 3200 document ಇದೆಯಲ್ಲ 54 ಮಾಡ್ಕೊಂಡು
54 ಅಲ್ಲ ಅದು 35/2 ಆಗ್ಬೇಕಿತ್ತು ಅಂತ ಅರ್ಥ.
ಬೌಂಡರೀಸ್ ಡಿಫರೆಂಟ್ ಎಕ್ಸ್ಟೆಂಟ್ ಡಿಫರೆಂಟ್.
ಆಯ್ತು, ನೀವು ಇದನ್ನ ಓದಿದಾಗ ನೀವು ಹಂಗೆ ಹೇಳಿದ್ರಲ್ಲ, ದಟ್ ಇಸ್ ನಾಟ್ ದ ಮೀನಿಂಗ್.
ಸ್ಟೇಟ್ಮೆಂಟ್ can you go to different statement?
Yes.
ಅದನ್ನ ನಾವು ಹೇಳಿದ್ರೆ it is not the first time they have come in.
Yes.
Can you go to the findings of the United at page 40 paragraph 22.
42.
Page number 40 paragraph 22.
Yes.
It is also true who has done mistakes without registered instrument, mistakes cannot be changed. As it is against such.
ಅದನ್ನ ಹೇಳದವ್ರು ಇದ್ರನ್ನಲ್ಲ, ಅಲ್ಲಿ ಸೇಲ್ ಡೀಟಲ್ ಒಂದ್ ಕಡೆ 54 ಅಂತ ಬಂದಿದೆ ಅಂತ, ಅದು ಮಿಸ್ಟೇಕ್ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ.
Mistake ಅದು ಬಿಟ್ಬಿಡಿ. Schedule of 35/2 ಇದೆ. But in the written statement also they claim that it is under 54 document 1954 1948 document they have issued.
Where is that?
Written statement. Can you go to the written statement? Page 201. Happy Kalago letter before. Can you go to page number 201?
Yes.
Paragraph 5. Declared in total of Sriranja by purchase this property under the sale deed number 1480 of 46. My document is denied. The first document. Shall put this so and so. As the presented copy is neither original nor legible plaintiff has produced this one. So 19 the property which the grandfather purchased in the year 1946 is denied. Can you make a note? Then number 209. Property different district does not hold any loans as the other vendor and capacity of net India passport one of the 34 Pundas with charge and substitution and safety taken therefore in along with Nanjapa with break India by under the registered safety so they were book one dated 11/5/1854 one of the 34 Pundas plan having same notice of copy of the same response then pay would want to learn. Documents are fabricated except admitted hearing. Shall deed dated 28/1846 is not presented original and not explanation was given about its whereabouts and reason to produce certificate copy. No details for reason to produce. So his case is that it is not the property which by Nanjapa purchased in the year 1946, which he claims in respect of the sole property.
Yes.
All along he is claiming title in respect of ceremony 54 of the year 1948.
Yes. Yes, that's all.
Page number 205.
Yes.
That's it.
205.
Subsequent are 10.4.1981, after executing the same date by dated 31/3/1981, in favor of Alienation and the Procedural, by one of the vendors in Anjappa, who is another the grant number 20, herein executed for the private stating that in the same date document of 3200 dated 9/1958, by mistake serial number was wrongly mentioned as serial number 54, whether it ought to have been serial number 35 or 2.
ನೀವು ಹೇಳ್ತಿರೋದಿಲ್ಲ ಅವ್ರು 54 ಅಂತ ಹೇಳ್ತಿದಾರೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿರೋದು ಮಿಸ್ಟೇಕ್ ಆಗಿ ಅದನ್ನ ಹೇಳ್ತಾ ಇದಾರೆ
1948 ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ serial number 54 ಇದೆ. ಅದನ್ನ serial number 35 ಮಾಡ್ಕೋ ಅಂತ ಓದ್ಕೋಬೇಕು ಅಂತ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ವಿ ಅಂತ ಹೇಳಿದ್ರು. Whether such a mistake given according to them can be rectified by way of affidavit. There shall be a registered document.
Yes.
It is a compulsory registered document under section 17 of the inspection.
Yes.
Have the read of the judgment of last
Yes. Yes.
It's a compulsory registered document. Whether an affidavit will prove the defect.
Yes.
So my respectful submission is why I applied from the year 2016. It's for the reason that I wanted to go. My grandfather is not alive in the football. My grandfather will be one of the reasons that I have executed an affidavit to say that it is not the 35 parcel I have sold. It is only 54. Inadvertently, it is mentioned as 54. So for which reason you have applied? Nevertheless, the issue regarding limitation is mixed question of law. It will be decided from the arbitration suit and where the evidence will be
Yes.
yes. So, by respect to submission is,
Yes.
till the suit is decided as substantial issues related to traditional procedure or establishment, where
Yes.
the status quo is to be made.
Yes. Well, there is no provision for reply to reply. Yes. Yes. Where is that all this reply to reply? Yes.
Why this is earlier theory, which was stipulated in favor of chicken.
Yes.
Theory also has fiction.
Yes.
Fiction.
No, what you want to say that?
Why? What I the reason of the discrepancy, how different, right? Because in the theory of Chittamaya,
There also it is mentioned therefore.
It was, no survey number was mentioned. Boundaries are said. Boundaries are very important. What boundaries Chittamaya has same boundaries as 42.
That you have argued. He has rightly explained that what is the intention of sale. Boundary is there. Why you are repeating, Mr.? Yes.
Because I am not finding out that one. It's hard to imagine.
No, he has argued that it is not that everybody has to be argued same point. Yes, tell it. Yes. 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 Farah? Yes. 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 This appeal is filed by plaintiff under Order 43, Rule 1R of CPC, challenging order dated 6th April 2023, passed by 4th Additional Senior Civil Judge, Bangalore, Rural District, Bangalore, in OS number 318 of 2020, thereby IA number 1 filed by the plaintiff under Order 39, Rule 1 and 2 are rejected. For the convenience, parties are referred to the ranking as per the trial court. The facts of the case are that the plaintiff has filed suit for declaration and possession, declaration and injunction. Along with that client, he has filed IA number 1 under Order 39, Rule 1 and 2. The trial court has granted an ex parte. What is that injunction granted? Granted an ex parte injunction order restraining the defendant not to put up any construction on the suit scheduled property. On service of summons, defendant appeared there through their counsel. They have filed their written statement and they have also filed died on 17/12/1997. He has executed in a will dated 18/5/1992 in favor of the plaintiff. The defendant has no rights or title over the suit scheduled property, right to interfere into that same. Hence, the plaintiff has filed a suit for injunction. OS number? OS number? First. Okay. 596 of 2016. In that suit, the defendant has filed a written statement claiming the title on the basis of the sale deed. Hence, the plaintiff has filed this suit for declaration. Yes. After withdrawing that suit, he has filed the suit for declaration and injunction. He further contended that the plaintiffs are claiming the title, the defendant are claiming the title on the basis of sale deed dated 10/4/1981, executed by the Nanjappa in favor of defendant number 3 to 10. It is very clear from the sale deed, the property which has been sold by the Nanjappa is survey number 54. The property which is sold under the sale deed is not in a suit scheduled property. Therefore, the defendant, without any right or title, they try to interfere into that suit scheduled property. Further contended that even the Nanjappa has given affidavit to mention that there is a discrepancy in the sale deed. Instead of survey number 35/2, it has been wrongly mentioned at 54. To that effect, the affidavit has been filed. No rectification deed has been produced before this court. Therefore, it is very clear that what is purchased by defendant number 3 to 10 is survey number 54, not a suit scheduled property. He further contended that the defendant number 3 to 10 has sold 2 acres, 25 guntas in favor of defendant number 12 to 29 by registered sale deed 7/12/2015. Even though in that sale deed, the survey number has been mentioned as 35/2, since their vendor itself has no title in respect of the sale, they have purchased only survey number 54. They cannot claim any right over survey number 35/2. Therefore, he contended that the defendant cannot be enter into the suit property. In support of his contention, he has relied on judgment of Apex Court (1999) 7 SCC 1 para 9 1999 5 SCC page 22 para 51 and 52 has contended that to protect that has contended that since the plaintiff has disputed that sale deed which is claimed by the defendant and the plaintiff has claiming a right on the basis of the registered sale deed dated 13/1/1946 and that will dated 10/4/1988, his interest has to be protected by granting an injunction restraining the defendant, or at least by granting in a status quo to be maintained that status of the property. Hence, he sought for allowing that appeal. Per contra, so and so learned counsel appearing for defendant number 3 to 10 has contended that defendant number 3 to 10 has purchased the suit schedule property from Nanjappa on 10/4/1981. Even though in the sale deed, the survey number has been mentioned as 54. In fact,
Is mentioned of 35, but it has to be written as 48. What is it?
there is nothing has been mentioned in the sale.
Discrepancy happened in 1948, and I have not purchased property.
Yes. No, I understood. Wait. Adರಲ್ಲಿ ಇವರಲ್ಲಿ ಇನ್ನೊಂದು contention. He further contended that the specific case of the plaintiff that the defendant that they have their vendor Nanjappa has purchased that suit schedule property by sale deed dated. What is that sale deed he has claiming? Huh? 10/9/1948. See, 9/1/1948, the sale deed is not related to survey number 35/2. Hence, the claim of the defendant itself is unsustainable. He contended that it is very clear, the defendant has contended that they have purchased the suit schedule property by a registered sale deed dated 10/4/1981. It is very clear in the sale deed that the property which they have purchased is survey number 35/2. It is very clear in the schedule that the schedule is related to 35/2. There is a discrepancy in that survey in the sale deed in respect of his vendor. Even though there is a discrepancy, but survey number and that boundary is his tallies. Therefore, he is contended that what is purchased by defendant number 3 to 10 is survey number 52/10, 52/2, the 35/2. That's yes. He further contended that since there is a two vendor, therefore there is a discrepancy in the survey number. He further contended that immediately after purchasing that property by defendant number 3 to 10, their name has been entered into revenue records from the date of purchase They are in the possession of the property. Further contended that out of 3 acres 24 guntas which they have purchased from one Nanjappa and Innobera Manugurappa. Vangurappa. Out of 3 acres 24 guntas, 2 acres 25 guntas has been sold in favor of defendant number 12 to 29. The remaining extent, the defendant number 3 to 10 has constructed a house. You are residing there. Yes. They have constructed a house. They are residing in that property. Therefore, trial court, after considering this materials, has rightly rejected IA filed by that plaintiff. So and so learned counsel appearing for defendant number 12 to 29 has contended that they have purchased this property from defendant number 3 to 10 on 7/12/2015, measuring 2 acres 25 guntas. Immediately after their purchase, their name has been entered into the revenue records. They have applied for conversion of the land from non-agriculture purpose, and they have obtained the necessary permission from the competent authority. Yes.
Sold by another party, none other than the property received by the received by the reserve party in 1940.
Yes. He further contended that yes.
That's really good.
Yes. He further contended that the defendant has obtained necessary permission from the competent authority to construct the building on the suit scheduled property. They have started that construction. Secondly, he has contended that some portions of the property has been acquired by the KDB, National Highway Authority, in the year 2016, 2005. The compensation has been paid in favor of the purchaser. At no point of time, the plaintiff or his ancestor has objected for payment of compensation. He further contended that the Nanjappa died on 17/2/1997. He has sold that property in favor of defendant number 3 to 10 on 10/4/1981. Till his death, at no point of time, he has raised any objection for alienation or he has filed any suit for cancellation. In this connection, he has referred Section 31 of Specific Relief Act. It is further contended that even though the plaintiff has claimed that they have a will in their favor executed by Nanjappa, even though Nanjappa has died on 17/12/1997, till 2006, they have not made any, 2016, they have not made any effort to change revenue entries or file any suit. Therefore, it is very clear that the plaintiff is not in the possession of the property. The trial court, after verifying the records, has rightly dismissed that application. heard the learned counsel for the parties. There was appeal paper. It is not in dispute. The plaintiff has filed OS number 596 of 2016 for injunction. In the said suit, the defendant has filed a written statement, has contended that they have purchased that property by a registered sale deed. Later, the plaintiff has withdrawn that suit and filed this comprehensive suit OS number 318 of 2020 for declaration and injunction. The specific case of the plaintiff that scheduled property originally purchased by grandfather Nanjappa on 13/1/1946 by a registered sale deed. The claim of the defendant number 3 to 10 that they have purchased this property from Nanjappa on 10/4/1981. In their sale deed, they have mentioned that Nanjappa has purchased this property on 9/1/1948. Therefore, he has contended that what is purchased in 1948 is survey number 54, not 35/2. As the parties has produced the sale deed dated 9/4/1981. Even though it is mentioned that the Nanjappa has purchased the property on 2/1/1948, but it is clearly mentioned that the property which Nanjappa wants to sell in favor of defendant number 3 to 10 is 3 acres 27 guntas in 35/2. Even boundary mentioned in that sale deed 10/4/1981. Yes. Yes, Mr. That is there in the sale deed. That will not go anywhere. You just keep quiet. Yeah. Even the schedule which is mentioned in the sale deed, the what is mentioned is survey number 35/2. Even as per that, and it is also not in dispute that from the date of sale, that is 1981, the revenue entry stands in the name of the respondents. Later, the respondent number 3 to 10 has sold this property in favor of respondent number 10 to 12, 12 to 29 by registered sale deed dated 7/12/2015. They have obtained the conversion of the land for non-agriculture purpose from the competent authority. They have also obtained the plan for construction of the building. That Kata stands in the name of the defendant. Therefore, it is very clear that as on today, the defendants are in the possession of the property and they have obtained necessary plan from the competent authority. In respect of defendant number 3 to 10, they have already constructed a building and they are residing in that part of the suitable property. Under these circumstances, the trial court has rightly, under these circumstances, I am of the opinion that the defendant cannot be restrained to put up any further construction. He may be permitted to put up a construction in accordance with law after obtaining necessary permission from the competent authority, but it's made clear that respondent cannot create any third-party interest till the disposal of the suit. The trial court is directed to dispose of the suit as expeditiously as possible, not later than 1 year from date of receipt of copy of this order. All the parties are directed to cooperate for early disposal. That is not necessary. Yes.
My contention is very same, the property they are claiming. It is been sold for this.
No, I am not giving any finding on the fact. I am saying that, yes, yeah, Agarwal Tagali, he contended that by sale deed dated 10/4/1981, they have purchased that property. Portion of the property has been purchased from Nanjappa and other portions of the property has been purchased from Venugurappa. Totally, they have purchased 3 acres 24 gunta.
And the same property, not other than the property.
That is what that said. Scheduled it.
This one, my day.
Yes. Yeah, that is also there. Yes. No, it is also made clear that the plaintiff shall not. No, there is an order from this court. Yes, you are there. You are there. No, you have admitted that they are in the possession. Only apprehension is that they cannot be alienated.
I make an undertaking that I will not interfere with the.
Order sheet. The problem is, I will see. Are you constructing any building there in your property? No, wait. Where is that plan? Show me that. Show me that plan where you are constructing.
Yes. Without plan, we not that. They are there every day. They are there. They are troubling us. They are not trying to.
Yes, that's what now I'm passing an order. Yes. Now the problem is, see, if you sold it to that third party who are an innocent purchaser after investing so much money, if you are unsuccessful, tomorrow they will suffer. I am protecting the interest. You are the builder. Today you will be there or will go tomorrow. But purchaser, after hard-earned money invested, they will purchase. They will not aware of this litigation and all. Tomorrow, if you are unsuccessful, then they will be suffer. Therefore, you go on with the construction because it is in the beginning, but don't create any third-party interest.
6 months suit can be decided. I will cooperate.
Yes. Now the problem is, suppose if you are unsuccessful, what about that purchaser? Yes. No, not you. Third persons. No, you will not say that. You go and take everything, then they will be there in the trouble. Therefore, their interest I am see, you can flood the property, you can take that loan, but not to create third alienate that property. No, see, that innocent purchaser will not aware of all these things.
Cannot be problem. Equities will have to be managed.
It's not really orders are there. Petitioner law has been changed now. Recently, several cannot be granted the person who is not in the position. The simple law.
Keep quiet, Mr. You have completed arguments. You keep quiet. Yes, otherly. There is a Supreme Court judgment, Mr. Supreme Court said the trial court is requested to hear. See what that said. If the construction is completed,
It's completed.
question clearly stipulates that matter. See, if the third party's interest is created upon the completion of the construction, the deed is question shall be clearly stipulated that matter is sub judice. All the sale shall be subject to the ultimate decision of the suit. Yes. Permitted to construct in accordance with law. Upon completion of the construct, the deed in question, if they are alienated, if the third party interest is created, Upon the completion of the construction, the deed in question shall clearly stipulate that the matter is sub judice and all the said deeds shall be subject to the ultimate decision of the suit. And the trial court is directed to dispose of the suit as expeditiously as possible, not later than 10 months from date of receipt of the copy of this order. All the parties are directed to cooperate for early disposal.
That is. Construction complete.
ಆದ್ಮೇಲೆ
ಆದ್ಮೇಲೆ.
ಹೌದು.
ಆದ್ಮೇಲೆ.
Yes.
So till such time, let them not get. Yes. ಆದ್ಮೇಲೆ. Facts are totally. In fact, I have read up on the judgment in so many cases.
Yes. 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 After construction that we can. Yes. If that time it is not constructed, it's.
So what I am trying to say is what? Let them proceed with the construction. By the time, even it will take more than 10 months. Before 10 months, we will complete.
You complete it. Complete it.
Let them not create.
No, this is my order. Mr. This is my order. Yes. If you are agreed, you challenge.
Pending application.
All pending applications are disposed.
Amendment parties. Finding of this plea will not be coming in the way of.
Yes, trial court is dispose of the matter in accordance with law without influencing any observation made in this order.
It should come here to the civil court.
Where is that earlier order? No, how will come, Mr.
They have that. I mean, in that is the case, it is always open for 7 to 5, even the defendant can maintain an application.
No, if they are trying to interfere, you move them for a trial. Yes. No, that you agitate before that court. No, you, if he is, see, if you are position, if you are in the position, if you try to interfere, then you know that what is the remedy you have to do. Yes.
Come as a-
All-
They should not come here.
No, mister, this is my order. No, I have closed. This is my order. If you want, if you are agreed, you challenge it. Yes, it is closed. If you agitate again, then I know that what I have to do. Yes. Be careful. Yeah, the question. No, that Basuraj, you have to amend the cost title. Yes.
Serial number 62, HB Rutresh. Serial number 62.
No, that's the unit of 62. Yeah. Yes, preliminary hearing. Movement. What is this, Mr. Rutresh? Yes. Respond one and including the name of the petitioner to final eligibility list. Where is that? What is this, Mr.? They are eligible. When that election, Mr.? No, you cannot be permitted to contest. You can be permitted to vote. Hmm. 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 No, why you have not been permitted? Hmm. 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 No, I didn't understand what is this case. See, now you want to contest for which election? Hmm. No, you have filed a nomination, then what is your grievance? Hmm.
They have received the nomination.
Hmm.
So far as that, it's number 2, 3, 4, sitting only casting their vote.
No, you have received that nomination. What is your problem now?
Accept I.
Aito, nomination accept admele election contest ಮಾಡ್ತಾರೆ. What is the grievance you are before me?
Have been disqualified.
Where?
That is the next year.
Where is the disqualification? Who has disqualified? Why it is disqualified?
Have been
If you are disqualified, then you have to challenge that. What is the disqualification? Why you have been disqualified? Hmm.
If I face it, I have not attended the general body meeting. But we have attended. You have done the fitness also.
Now, where is that disqualification? Water list, because that they are not attended that. Because of that, their name may be, they may be, yes, then he is entered. Yes. Now, what is that relief interim order you are why? Court permitted that vote in that upcoming election, that's all. What is that interim prayer now? ನೀವು contest ಮಾಡಿದಿರಲ್ಲ. Why you have not sought? Yes, thoroughly. He has filed nomination already. No, is it when that scrutiny of the nomination? 3-9. Returning officer in the Sangada notice board nalli, as he rejected your nomination paper. ಆಯ್ತ್ರಿ ನಾಮಿನೇಷನ್ ರಿಜೆಕ್ಟ್ ಅಂತ ಹಾಕ್ಬೇಕಲ್ಲ. ನಾಮಿನೇಷನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ ಬೇಕಲ್ರಿ. ಅಲ್ರಿ ಅದಕ್ಕೆ ಬರನ್ರಿ ಆಯ್ತು ಇಂಟ್ರಿ ಮಾಡಿ ನಿಮ್ ನಾಮಿನೇಷನ್ 3/9/23 ಏನಾಗಿದೆ ಆಫ್ಟರ್ ಸ್ಕೂಟ್ನಿ ನಾಮಿನೇಷನ್ ಇಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್ then what you want then your nomination is accepted ಆದ್ಮೇಲೆ ಇನ್ನೇನ್ ಬೇಕ್ರಿ. Yes. Or issue notice. Government advocate is directed to take notice for respondent number 1, 3, and 6. Learned counsel for Kiran Kumar is directed to take notice for 2. Issue emergent notice to 7. Learned counsel for the petitioner is directed to serve 2 sets of copies to respective counsel. Petitioner is permitted to cast their votes in upcoming election to the 7th respondent society scheduled to be held on 10/9/2023. Subject to result if he subject to result of this petition. Yes.
After this move matter for order serial number 1, CH was for petitioner, government advocate.
Tomorrow. Yes. Did you notice? Are you copy kotillenri? What is that office objection, Mr.? Whether the petitioners on the same cause action age proof signature of the petitioners to be accepted by the advocate and wakalat. Yenri? Urgency wakalate accept madane ಆಗ್ತಾರೇನ್ರಿ? What is this, Mr.? Ranking of the parties to be assigned before that signature in the wakalat. ಏನು ಹಾಕಿಲ್ಲಲ್ಲ ಯಾವ ಪಾರ್ಟಿ ಯಾವ ರ್ಯಾಂಕಿಂಗ್ ಅಂತ ಅದು ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಮಾಡಿ. Yes. Issue notice. ಯಾರ್ಯಾರಿಗ್ರಿ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದ್ದೀರೇನ್ರಿ? ಎಷ್ಟು ಕಟ್ಟಿದ್ದೀರಾ? Yes. Government advocate is directed to take notice for 1, 3, and 4. Kiran Kumar for 2. Issue emergent notice to 5. Directed to serve 2 sets of copies on government advocate and Kiran Kumar. Both respondent returning officer is directed to permit the petitioner to cast their vote in the election to be held on 5th respondent society. Then when that election scheduled to be held on 8/9/2023, if they are duly members of fifth respondent society. Yes.
Hearing matter, serial number 2, Ravindra Prasad Ray.
Yes, Ravindra Prasad. Where is Ravindra Prasad? Yes. What is this, Mr.? Kodi. Copy ಕೊಡ್ರಿ government advocate. Directed to take notice for respondent number 1, 345. Kiran Kumar for 2, notice to 6. Fifth respondent returning officer is directed to permit the petitioner to cast their vote in the election to be held on 8/9/2023 to sixth respondent society if they are duly members of the society.
Serial number 3,
Same, huh? Entry ಮಾಡೋದೊಂದು ಮಾಡ್ಬಿಡಿ. Entry ಮಾಡೋದೊಂದು ಮಾಡ್ಬಿಡಿ first. Other matter hearing. Yeah. 63. Yes. 27. Yes. 64. Line. Yes. Next week. 15th ಆಗಲ್ಲ. 29. ಇಲ್ಲ ಎಲ್ಲಿ ಎಲ್ಲಾ ಮ್ಯಾಟರ್ಗಳು ಬಿಲ್ಡಪ್ ಆಗ್ಬಿಟ್ಟಿದೆ. Hearing now that 29. Yes.
ನಾವು